think we can go, right? We got enough here to get.
Yeah, we'll get into an amendment at some point, people.
Yeah. Committee will come to order without objection. The chair is authorized to declare recess at any time pursuant to Committee Rule 2, House Rule 11, Clause 2. Chairman may postpone further proceedings today on the question of approving any measure or matter or adopting an amendment for which a recorded vote is ordered. The chair now recognizes the gentleman from Texas to lead us in the Pledge of Allegiance.
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Pursuant to the notice, I call up H.R. 7640, the Shutdown Sanctuary Policies Act, for purposes of markup, and move that the committee report it favorably to the House. The clerk will report the bill.
H.R. 76.
Without objection, the bill will be considered as read and open for amendment at any point. The chair now recognizes, before I recognize the gentleman, I want to recognize our sheriffs who are and law enforcement personnel are here today. Thank you so much. From the great state of Maryland, thank you for being here today. I know you're concerned about this issue. And now I want to recognize the sponsor of the legislation, the gentleman from California, Mr. McClintock, for an opening statement.
Thank you, Mr. Chairman. And as you've noted, the sheriffs are here today, not only in support of this bill, but also in opposition to the state's announcement that it will no longer enter into 287G cooperative agreements with the federal government, which is what this bill is about. Yesterday, DHS Secretary Noem testified that in its first year, the Trump administration has deported more than 500,000 illegal aliens with criminal records. And in the same year, we've seen record drops in crime across our country, including the lowest homicide rate in 125 years. It turns out that when you remove 500,000 criminals from our streets, crime goes down. Who would have thought it? But not if the Democrats had had their way. As the chairman said yesterday, 1/3 of the American population lives in so-called sanctuary jurisdictions controlled by the Democrats, which forbid law enforcement from cooperating with federal authorities. These policies specifically protect illegal aliens who have criminal records, who are taken into custody by local law enforcement, from being turned over to federal authorities for deportation. Instead, the Democrats release them back into our communities. It should come as no surprise that when the president put the proposition to them that the first responsibility of the government should be to protect American citizens and not illegal aliens, the Democrats just glared back at him. The Angel families who visited us yesterday were heartbreaking, silent testimony to the human toll the Democrats' open border policies have taken on American families. In my congressional district in rural California, every county sheriff wants to cooperate with federal authorities to remove illegal aliens from their communities. In fact, last year, the Tulare County Sheriff, who's in the next district over from mine, testified to our subcommittee that half of the crimes that his department deals with are being committed by illegal aliens. But state law forbids local law enforcement from cooperating with ICE in any way. Meanwhile, the federal government sends millions of dollars for federal law enforcement purposes to the state of California that refuses to enforce federal law. H.R. 7640 is a game changer. It preempts sanctuary laws that forbid law enforcement officers from cooperating with federal immigration authorities. It allows local jurisdictions to enter into agreements directly with the federal government to enforce immigration law. It protects law enforcement officers who cooperate from ICE from being sued or fined for upholding the law. It allows victims of criminal illegals released by sanctuary jurisdictions to sue them for damages caused by these releases, and it takes the federal law enforcement funds away from sanctuary jurisdictions and gives these funds instead to those jurisdictions who are actually enforcing federal law. The chairman's pointed out that 11 states have declared themselves separate from federal law. Ironically, that's the same number of states in the old Confederacy. They both revived the discredited doctrine of nullification that we thought had died with the Confederacy, the notion that a state can simply ignore or nullify a federal law that it doesn't like. That notion is fatal to a federal republic like ours. It is time to bury that doctrine once and for all. To the sheriffs and deputies and police officers who've been forced by sanctuary laws to endanger their citizens by releasing dangerous criminals back into their communities, this bill is for you. To the Angel families who have lost loved ones because sanctuary jurisdictions deliberately set loose the monsters that then killed or assaulted or raped or robbed or maimed or injured your loved ones, this bill is for you. To Americans across the country who found yourselves at the mercy of criminal gangs and thugs imported by the Democrats' open border policies, this bill is for you. I hope Americans will pay attention to the debate that's about to unfold. If you watch, it will become crystal clear that the Democrats are actively fighting to return criminals into our communities rather than to deport them as the law requires and as common sense commands. This specifically applies to illegal aliens who not only have no right to be here, but to a specific class of illegal aliens, those who have been arrested or convicted or committed of other crimes and are already in the custody of law enforcement. Should they be released back into our streets, or should they be deported back to their own countries and never be allowed to menace ours again? That is the question before us. And with that, Mr. Chairman, I yield back.
Gentleman yields back. The ranking member is now recognized for an opening statement.
And thank you kindly, Mr. Chairman, and welcome to our sheriffs and other law enforcement who've joined us here today. The gentleman from California rushed to give President Trump credit for dramatic decreases in violent crime that have been taking place over the last several years, long before he ever got to office. Beginning in 2022, under President Biden, the country experienced a major reduction in homicide and violent crime. That trend continued in 2023, 2024. By 2024, nationwide murders had dropped by 26% since the peak in 2020, with 2024 having the largest one-year drop in murders ever recorded in American history. On the day that Trump was inaugurated, crime had fallen to 60-year lows. So it's true that the downward trend has continued, despite the fact that the Trump administration, as everybody in this committee knows, cut hundreds of millions of dollars in aid to state and local law enforcement and victims organizations as soon as they got into office. That was the first thing that we were fighting about in this committee when Doge and Elon Musk cut hundreds of millions of dollars in grants that had already been slated for our communities and for our state governments. But look, let's get to the question of the bill before us today. Now, we often say in our committee that to believe in the Constitution is to respect it and defend it, even if it gets in the way of your momentary political passions or your party conference's policy agenda. So who will stand up for the 10th Amendment? The right of the people in our state and local governments not to be conscripted and coerced into service and commandeered by the federal government to implement federal policies chosen at a different level of government. You might love what ICE has been doing in Minneapolis. You might hate it. You might love the idea of sanctuary cities, or you might hate it. But regardless, this bill goes way beyond sanctuary cities. This bill is a full-blown assault on the 10th Amendment of the Constitution. It's an attempt to force every state and local government in America to turn every sheriff, police officer, and other public employee, not just for the question of detainers and sanctuary, which is what our friends keep talking about, but for every other aspect of immigration law, into an agent of the federal government and of this administration's basically incompetent and dangerous immigration operations. It's not enough for our colleagues that DHS now has more than 80,000 police officers of its own, more than the number of officers in New York, Chicago, LA, Houston, Washington, D.C., Baltimore, Las Vegas, and Dallas combined, or that it is a larger annual budget than 150 nations on earth. They now also want to force every local, state, and police officer in America essentially to be deputized federal law enforcement agents with respect to immigration, to participate in their operations and to follow their policy orders. Now, fortunately, We don't have to argue this from the beginning because there's a Supreme Court decision right on point from 1997, Prince versus United States, which I'm sure our friends in law enforcement know well, where Justice Scalia decided for the court that the federal government may not compel state and local governments and state and local officials to enforce and implement federal laws. The decision struck down the provision of the Brady Handgun Violence Prevention Act that required local law enforcement, like sheriffs and police chiefs, to cooperate with the ATF and the FBI to conduct violent criminal, fugitive, and illegal alien background checks on all handgun purchasers in America. The purpose of the legislation was, of course, to prevent the violence and the bloodshed of innocent Americans caused by hundreds of thousands or millions of unqualified applicants obtaining a firearm. So there was a very clear public safety rationale. But the Supreme Court held that despite the fact that it actually would improve public safety and reduce violence, congressional commandeering of state and local officials, state and local governments, and state and local taxpayer resources violates the 10th Amendment principles of federalism and dual sovereignty, the separate political sovereignty of the states and local governments. The Constitution simply does not grant Congress the power to force state executives to administer federal programs, even for a paramount or excellent public safety purpose, like saving lives of the people, as the Brady background check indisputably did, and as the Supreme Court accepted for the sake of arguments, but they said it violated the Constitution. It was Sheriffs Jay Prince of Montana and Richard Mack of Arizona who challenged the federal requirement, arguing that it unconstitutionally compelled them as local law enforcement officials to implement federal laws. The court found that coercing state officials and local officials to enforce federal laws violates the sovereignty and the integrity of state and local governments under the 10th Amendment, blurring the critical lines of political accountability in the American federalist system and conscripting state and local taxpayers to subsidize federal priorities with their limited local tax dollars and revenue. So the bill before us today would do the exact same thing. It would prohibit states from having any laws or policies that set any limits on how much time and resources state and local officers would spend on federal immigration law enforcement. What could be a greater assault on state and local government than saying that these local officials can be conscripted and then supervised by the federal government, which is going to immunize them now for any lawsuits that might ensue, to do the bidding of the federal government. So they also throw in another cardinal unconstitutional feature, a Godfather offer, what the Supreme Court has called an unconstitutional condition, here an effort to condition a community or a state's receipt of federal funding on the surrender of a 10th Amendment power. In another decision, National Federation of Independent Business versus Sebelius, the court noted that the 10th Amendment's prohibition holds true whether Congress directly commands a state to regulate or indirectly coerces a state to adopt a federal regulatory system as its own. This bill would defund state and local police departments simply because they dare to require that all of their employees' time be used to be working on state and local laws rather than federal laws. So, my friends, again, let's not confuse the policy question from the constitutional question. I would hope that everybody here on the committee who believes in the 10th Amendment, as well as the Second Amendment implicated in the Prince case, would stand up for these constitutional principles. And I yield back to you, Mr. Chairman.
Gentleman yields back. Without objection, all other opening statements will be included in the record. The chair now recognizes the gentleman from California to offer an amendment in the nature of a substitute.
Mr. Chairman, I have an amendment at the desk.
Clerk will report the amendment.
Amendment in the nature of a substitute.
Without objection, the amendment in the nature of a substitute will be considered as read and shall be considered as base text for the purposes of amendment. The chair now recognizes the gentleman from California to explain the amendment.
Thank you, Mr. Chairman. First, in response to the ranking member, who wants to conflate this bill with previous laws that the Supreme Court have held unconstitutional. Simply, it's not the case. This bill does not command law enforcement officers to do anything or take part in any federal activity, such as conducting background checks as in Prince versus the United States. It does not compel them to enact or enforce a federal regulatory program, such as taking title of nuclear waste as in New York versus United States. And it does not dictate what a state legislature may and may not do, such as prohibiting state authorization of sporting gambling, as was clear in Murphy versus National Collegiate Athletic Association. This bill does not issue an order directly to state and local jurisdictions. Instead, the bill simply says that if you restrict or prohibit the federal government from doing its job to enforce federal immigration law, you cannot receive related federal grant funding. There's no compulsion, no command, no commandeering. In fact, it is sanctuary states and cities that want to commandeer federal law by undermining the federal government's immigration enforcement every step of the way. This bill's careful structure is permissible under Supreme Court precedent, and I urge my colleagues to reject this false argument. And now to the amendment in the nature of a substitute. It simply makes a small technical change to the short title and clarifies that sanctuary city victims or their families may pursue a civil action against jurisdictions for harm that occurred before the enactment of this act. I yield back.
Gentleman yields back. Who seeks recognition? Gentlelady from Washington is recognized.
Thank you, Mr. Chairman. It's been 1 month since we saw DHS officials kill 2 people in cold blood in Minnesota. We've seen countless U.S. citizens detained and beaten for exercising their First Amendment rights. We've seen ICE agents break down doors of U.S. citizens without a warrant in violation of the Fourth Amendment. And we just found out ICE agents admitted to killing another U.S. citizen in San Antonio last year. But instead of addressing these egregious abuses or making sure that every federal officer acts in accordance with the Fourth Amendment, we're taking up this bill to force every single state and local law enforcement agency to act as immigration agents. And let's be clear, that is what we're doing by withholding these federal funds if you don't like the policies that state legislatures implement. And let's be clear, this bill is an even more radical version of the bill the majority moved 9 years ago. Republicans passed their big bad betrayal bill, giving DHS $175 billion to conduct immigration enforcement. DHS has plenty of money to hire all the new immigration enforcement agents they want, but Republicans now want to force state and local authorities to join them in their lawless actions. So let's talk about what this bill does, because this is not merely about allowing cooperation. This bill would coerce state and local law enforcement to help them round up immigrants by threatening to cut off law enforcement funds if they do not comply, even though multiple courts have held that this is illegal, and numerous research studies and law enforcement officials have confirmed that keeping the long-standing distinction between federal immigration and local law enforcement helps keep communities safer. Moreover, detainers raise serious concerns as they are not orders from judges, and they often don't have sufficient probable cause. They are simply requests for local law enforcement agencies to hold individuals in custody for up to 48 hours. And this is not necessarily for people who have a final order of removal, as Republicans on the other side stated during the Kristi Noem hearing yesterday. In fact, that's often not the case at all. Detainers have been issued for U.S. citizens, including one U.S. citizen who was detained for 1,273 days. Ultimately, adopting welcoming policies and refusing to comply with detainers protects local law enforcement from being held liable for unlawful arrests and detention. Immigration enforcement is the job of the federal government, not states, not cities, not localities. There are many reasons that law enforcement themselves choose not to enforce immigration law. In 2019, my home state of Washington passed the Keep Washington Working Act with bipartisan support. It is a common sense law to ensure that local police remain focused on public safety rather than enforcing federal immigration law. We know that when local police act as immigration agents, immigrant communities and their families are much less likely to come forward to report a crime when they are a witness or even a victim. It destroys the trust police the trust that police rely on to preserve public safety in communities. And courts have ruled multiple times that states have the right to enact laws like Keep Washington Working Act. Our law does allow information sharing with the federal government when necessary for an ongoing criminal investigation or pursuant to a court order or a judicial warrant. That is how we as a state decided to handle immigration enforcement, because we wanted to ensure that our limited resources went to protecting our citizens, not rounding up students, fathers, mothers, kids, and law-abiding community members. And I fully support my state's effort to ensure that everyone in our state follows our law. Now, we're not alone. Many states like California, New Jersey, Oregon, Illinois, and Colorado have made similar choices. And I would like to point out that no law enforcement organizations support this legislation. That is because organizations like the Major Cities Chiefs Association has repeatedly reaffirmed that across the country, if law enforcement officers are viewed by members of the immigrant community as colluding or working with immigration law enforcement officers, this would result in increased crime against immigrants. This is a quote, result in increased crime against immigrants in the broader community, create a class of silent victims, and eliminate the potential for assistance from immigrants in solving crimes or preventing future terroristic attacks. Now, we already have a problem with how people are seeing ICE and CBP in this country. There is very little support across the country for what this administration is doing. Now you want to make it worse by forcing local jurisdictions and states to enforce federal immigration laws that honestly bring liability on local police departments. That's why so many local police departments don't want to do this, because they don't want to absorb the liability that exists. And with that, I yield back.
Gentleman yields back. The gentleman from Texas is recognized.
Thank you, Mr. Chairman. I just want to emphasize that all this bill does is to make sure that local jurisdictions cannot shield the truly bad hombres from deportation, who need to be deported. They have no business in our country. Zero. I'm an old sheriff. I'm with you all. This right here is what I mean by bad hombres, right? Here we have a few that ICE picked up in and around my district. Jose from Mexico, arrested Harris County, practiced dentistry without a license, sexually assaulted one of his patients. This guy right here. Juan from Mexico, arrested in my county, Fort Bend County, indecency with a child. Here he is. Jose, he's from Ecuador, arrested in Katy, Texas, assault and larceny. Juan Garcia, Mexico, arrested in Harris County, assault on a family member by strangulation. Would you like to have him in your family? Look at this guy. Carlos from Honduras, arrested in Harris County, sexual assault of a child. We know the Republican Party, we want to protect the American people. That's what Donald Trump wants to do, protect the American people from these bad hombres. They want to let them in. It's quite clear. We know who wants to let these guys in. Thang Lee from Vietnam, arrested in Katy. A lot of forgery. You sheriffs know what I'm talking about, dealing with all the forgery we have. Anyone that does not support this bill thinks these types of people, these individuals, should be allowed to remain in our country and continue to prey on the American people. It is stupidity at its core. Donald Trump now has to clean up the mess. With that, Mr. Chairman, I yield back.
Gentleman yields back. The gentlelady from Georgia is recognized.
Mr. Chairman, I'm not sure if we're ready to have an amendment at the desk. So,
Who seeks recognition? The gentleman from Tennessee is recognized.
Thank you, Mr. Chair. Yesterday, we had a committee meeting. We had Kristi Noem sitting right down there. Behind her were all these people who had family members who had been killed by illegal immigrants, I guess. And I expressed my sorrow for what they went through. I don't think anybody else on this dais did that. They might have, but I did, because I thought they were here and we ought to express our sorrow and show that they're here and we recognize them. And then I said, and I don't know exactly because I haven't gone back to look at it, I said that they were just as likely or more likely
to have their family members attacked or killed by a person who was born in America and an American citizen, because the facts show that immigrants, illegal immigrants, commit less crime than people born in America. That's a justice report from 2024 and a newspaper report that I had for my city and my state. They commit less crime. That was all. And then the Department of Homeland Security has on the front page a story about me suggesting I did something terrible for these people because Kristi Noem interpreted it that way. I didn't talk about her killing her dog, which was awful, an indication of her behavior. I didn't talk about the fact that she hasn't had investigations into the people who killed Mr. Pretty or Miss Good. No investigation. She says, oh, the FBI's doing it. You know, she should have done it. Law enforcement should have their own people do it. They should have an internal affairs department. But that was ridiculous. Then I got back to my office yesterday afternoon, Mr. Chairman, and I had a Baptist minister from Memphis, one of the most respected Baptist ministers in Memphis, in my office, letting me know that 2 Afghans in Memphis who have done nothing wrong and are members of his church and are Christians have been picked up by ICE. One man was picked up. He'd done nothing wrong. He'd been in the country for many years. He'd been an interpreter for our troops in Afghanistan. And they took him to the airport and had him call his wife and bring their children to the airport with her to be with him. And they did that, and they flew them to Billy, Texas, where they're currently being held. 4 Afghan Christians, and they were taken with no criminal offenses that they'd committed. They came in this country legally. Now, our president irrationally asked all Afghans to be sent out of this country no matter what they did for our troops after one crazy Afghan killed a reservist here. That was terrible, but there was no reason to take every Afghan who's been in this country legally and had helped us as interpreters and send them back to Afghanistan where they'd be killed. I don't know where they were going to send them. And then another person, an individual who was a member of his church, young man, picked up, sent to Louisiana, and they wanted to deport him to Brazil. There are reasons why cities don't want to cooperate with ICE. ICE has become and is recognized as the worst agency in this government. They have no respect for citizens. They do not act like law enforcement. Law enforcement acts with regard for people and to serve you. They wear badges, they have their names on their uniforms, they don't have masks on, and they don't just come up and break your window and pull you out. And they don't shoot you in the face or shoot you in the back 10 times when you've done nothing wrong, certainly nothing violent. But they did nothing wrong, Miss Good or Miss Pretty, nothing that a law enforcement officer would kill them for, because they can only use deadly force under certain circumstances. ICE has gotten totally out of control, and this committee needs to deal with it. It's the most un-American committee a law enforcement type unit we've ever had. It's really not law enforcement, it's a paramilitary group. And if you look up the definition of paramilitary, which I did, that's what ICE is. We have a paramilitary group operating on our streets in America, taking people's rights away and treating them and killing them without any oversight. And absolutely, it's Ms. Noem's fault. She needs to be impeached. If she doesn't resign, she does need to be impeached because she is a discredit to this government and to her president. It was said that she didn't fire the head of the counterintelligence group that deals with Iran. He was fired by the FBI, but they said she didn't fire him because Mr. Lewandowski said that would reflect poorly on her, who she hired him, if she fired him. Well, she reflects poorly on Donald Trump. I yield back.
Gentleman yields back. The gentleman from Arizona is recognized.
Thank you, Mr. Chairman. Imagine a convicted child rapist and self-admitted gang member released from prison because a sanctuary jurisdiction ignored a federal detainer, or a Trinidad suspect with a history of assaults and threats freed despite mandatory detention requirements, or an aggravated felon deported 4 times, released 3 separate times by a local jail that refused to honor ICE requests. These are not hypotheticals. Those things really happened. And many of these stories have tragic endings, and that is the reality of sanctuary policies. The crazy attempt at logic that angel families would be more likely to be harmed by U.S. citizens is flawed. Why is it flawed? Because they weren't harmed by U.S. citizens. They were harmed by illegal aliens that had ICE holds that should have been detained. That's asinine. That argument is asinine. Laken Riley, 22-year-old nursing student, was murdered while jogging near her campus. Her killer was unlawfully present in the U.S. Rachel Morin, a mother of 5, was brutally raped and murdered on a hiking trail in Maryland. Her killer had entered this country illegally and remained here. Jocelyn Nungary, just 12 years old, was sexually assaulted and murdered. 2 Venezuelan nationals unlawfully present in the United States have been charged. Laura Wilkerson, Javier Harvey Vega Jr., Elizabeth Medina, Dakara Thompson, Nate Baker, Fletcher Harris, Skylar Provenza, Ivory Smith, Rocky Jones, and my constituent namesake of my legislation to end the catch and release program, Grant Runnebeck. The list goes on and on of victims of illegal aliens, many of whom were in custody but released by sanctuary cities. This is a small sample of all the victims killed by criminal illegal aliens who never should have been allowed in this country. The radical left has made it clear that they do not care about protecting U.S. citizens. They're interested in protecting illegal aliens. From October 2022 through early 2025, state and local jurisdictions declined more than 25,000 ICE detainers. ICE data showed that sanctuary jurisdictions have released individuals charged with homicide, sexual assault, weapons offenses, and serious gang activities. In one case, a violent offender with 28 prior arrests was released after multiple detainers were ignored. 15 of those arrests occurred after the first detainer that was ignored. In another, a previously deported criminal alien was released repeatedly only to go on and allegedly commit rape. These are not policy disagreements. These are public safety failures. These are bad policy failures. These are bad leadership. And it is just, as my friend from Texas said, the core of stupidity. Federal immigration law is not optional. The Supreme Court has made clear that immigration enforcement is a federal responsibility. And 8 U.S.C. Section 1373 prohibits state and local governments from restricting the sharing of immigration status information with federal authorities, and yet sanctuary jurisdictions do exactly that. They violate federal law. Federal law also prohibits harboring or shielding removable aliens from detection, yet sanctuary jurisdictions do exactly that. They harbor and shield removable aliens from detention. They're violating federal law. More than 200 sanctuary jurisdictions openly defy federal law. They nullify federal authority in practice while demanding federal funding in return. There is no obligation for the federal government to continue funding these sanctuary jurisdictions, and that's one of the reasons I support this bill. President Trump and his administration are enforcing the tools Congress provided. Secretary Noem, Bordazar Homan, and ICE are restoring accountability and delivering results. But executive action alone cannot overcome systematic obstruction at the local level. That's why H.R. 7640, the Shutdown Sanctuary Policies Act, is necessary. This bill prohibits sanctuary laws that restrict cooperation with federal immigration authorities. It withholds key federal law enforcement grants, including COPS, burn JAG funds, from jurisdictions that refuse to comply with federal laws. It clarifies probable cause standards for detainers and provides legal protection to officers who cooperate in good faith. And importantly, it creates a private right of action so that victims of crimes committed by released criminal aliens can seek accountability. This restores the rule of law. And Mr. Chairman, I would also urge us to bring H.R. 7200, which requires E-Verify before a state issues a CDL, to this committee for markup and take it to the floor. With that, Mr. Chairman, I yield back.
Gentleman yields back. The gentlelady from Georgia is recognized.
Mr. Chair, I have an amendment at the desk.
Clerk will report the amendment.
Amendment to the amendment in the
Without
nature.
objection, the amendment will be considered as read. Gentleman from Arizona reserves a point of order. The gentlelady from Georgia is recognized to explain the amendment.
Thank you, Mr. Chair. And once again, I'd like to reiterate what the ranking member did say, and I will quote him once again. Who will stand up for the 10th Amendment, the right of the people in their state and their local governments not to be conscripted and coerced into service and commandeered by the federal government to implement federal policies, end quote. So, Mr. Chairman, to undergird this truth, my amendment is very, very straightforward. It strikes areas in the bill that would render ineligible any state or local government that chooses under its will, as determined by the Constitution, to leave federal immigration enforcement to federal agents. Removing this provision prevents the unnecessary loss of funding from multi-jurisdictional anti-drug, anti-trafficking, and anti-gang task forces. It protects resources that departments rely on to hire officers, train personnel, and keep communities safe. This bill is a constitutional violation of the 10th Amendment. Plain and simple, the party of states' rights that once believed states should have the power to determine their own laws, yet again seeks to override state law and coerce state and local law enforcement into carrying out federal immigration enforcement, a responsibility that belongs to the federal government. Talk about overreach and bullying. This bill is an attempt to bully states into compliance by threatening to wipe out critical public safety funding unless they redirect their limited personnel and resources to several federal priorities. In my home state of Georgia, home to the busiest airport in the world, we face constant public safety threats, including sex trafficking, labor trafficking, and drug trafficking that are tackled by a number of partnerships. Our state and local law enforcement officers operate a number of dedicated task forces that focus on anti-human trafficking operations, drug interdiction, anti-gang operations, and other major crimes. Burn JAG grants provide funding for these partnerships and task forces and for life-saving equipment, training officers, and hiring and retaining officers and other personnel. All this good that this funding provides, and yet this bill threatens to end it all because certain localities choose not to force non-federal law enforcement officers to do a federal job, a choice that is theirs to make because of the Constitution. These grants also support drug treatment initiatives and crime prevention programs. For a party that's claiming to be so tough on crime, taking a step to eliminate funding from all of these programs seems counterintuitive. I'll lay it out plainly. Reducing investments in prevention, enforcement, and rehabilitation does not strengthen public safety. It makes it worse. It weakens it. Every year, 10 million people in this country are subjected to domestic violence. On average, it takes about 7 times for a person to leave an abusive relationship for good. Over the course of that time, law enforcement is able to help with programs and assistance that's provided and supported by Burn JAG. Domestic violence does not disappear based on a city's immigration enforcement policy. Victims of domestic violence can be anyone from anywhere. Diverting already understaffed departments away from responding to domestic violence calls or dismantling the sex trafficking networks in order to perform federal immigration functions does not protect victims. It leaves them more vulnerable and at higher risks of violence. This country is facing a nationwide law enforcement shortage. We have long recognized the need to support you, the state, local, and tribal agencies through hiring and training programs. This is why the Cops on the Beat program was enacted and funded for you. Yet this bill threatens to withhold that very support from you, the states and localities that exercise their constitutional authority to set their own enforcement priorities. This bill does not encourage partnerships or collaboration. It coerces unwilling participants instead. The section of this bill is a stick. It's not a carrot that would force states to stretch their tight budgets even further in the name of federal immigration enforcement or face crippling financial consequences. It will erode trust between our communities and law enforcement that we have all worked to improve, making our communities less safe and divide our communities and law enforcement even further apart. I urge my colleagues to vote in favor of my amendment and to keep both our communities and you, our officers, safe. And I yield.
Gentlelady yields back. The gentleman from California, Mr. McClintock's recognized.
Thank you, Mr. Chairman. First of all, let me
Did we
respond to the gentlelady from Washington who...
draw a point of order? No, the gentleman from California is recognized.
Thank you. First, I'd like to address the argument of the gentlelady from Washington who decries the violence that we've seen on the streets of Minneapolis as sanctuary jurisdiction. We all decry that violence, but we've not seen it in jurisdictions that cooperate with law enforcement. Texas, which cooperates with ICE, has 10 times the deportation rates per capita as we see in Minnesota without the violent incidents by lawless mobs that are incited and inflamed and encouraged by these new Confederate Democrats. And as Abraham Lincoln said, there is no grievance that is a fit object for redress by mob law. If the Democrats really want to stop the violence, the answer is to cooperate with federal authorities to turn over criminal illegal aliens when they're already in custody and can be transferred without the necessity of law enforcement officers going back out into the field, tracking them down when they're at large. If the Democrats really want to stop the violence, they should stop their incendiary rhetoric, demonizing federal law enforcement as stormtroopers, kidnappers, and Nazis. We've already heard a little of that rhetoric today. If the Democrats really want to protect immigrant communities, they should cheer federal law enforcement as they remove dangerous criminals from the very neighborhoods where there are high concentrations of immigrants. These crimes are disproportionately committed in immigrant communities against immigrants. Now, the gentleman from Tennessee says that illegal immigrants commit less crimes than the general population. They love to say that. Well, my first response is tell that to all of the angel families who were here yesterday. Put aside the fact that illegal aliens shouldn't be in this country to commit these crimes in the first place. Their claim is simply untrue. The Democrats love to cite a study of Texas inmates to support this outrageous claim. But that report deceptively classifies suspects when they're initially arrested, when we don't know their legal status, and then ignores the numbers when they're ultimately identified as illegal immigrants. When the Federation for American Immigration Reform looked at the reimbursement requests from states for the cost of locking up illegal aliens, they found that illegals are 231% more likely to be jailed for crimes in California, 440% more likely in New Jersey, and 60% more likely in Texas. Last year, NYPD officials said that most of the crimes they were dealing with involved illegal aliens. The Tulare County Sheriff testified to our subcommittee last year that half the crimes he's dealing with involved illegal aliens, including the Sinaloa cartel that's insinuated itself deeply into our communities. And yet the Democrats use this utterly debunked lie to argue in favor of not deporting illegal aliens who've been arrested for committing crimes in our communities and who have no legal right to be here, and that the law requires be removed from our country. It's astonishing to me that Democrats would use such discredited claims to argue that we should keep these criminals on our streets and preying on our people and on our immigrant communities as well. As to the amendment before us, it makes no sense for the federal government to provide millions of dollars of federal law enforcement funds to jurisdictions that refuse to enforce federal law. This does not eliminate the funding. It simply redirects it from jurisdictions that choose not to enforce federal law and gives it instead to those jurisdictions that choose to enforce federal law. The Supreme Court has made it clear that, incident to its spending power, Congress may attach conditions on the receipt of federal funds and has repeatedly employed the power to further broad policy objectives by conditioning receipt of federal funds upon compliance by the recipient with the federal statutory and administrative directives. That's a direct quote from the Supreme Court. Even the far-left Ninth Circuit has acknowledged that Congress has the authority to condition federal funds on compliance with federal immigration law. That's precisely what this bill does. I yield back.
Yields back. The gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I rise in strong support of the amendment offered by the gentlelady from Georgia. As always, Ms. McBath is a woman after my own heart, but she goes right to the heart of the issue, which is the sovereignty, the integrity of our state and local governments under the constitutional system. Now, there are at least two unconstitutional features to this legislation. One is the one at issue in this amendment, which is the Godfather offer, saying that if the states and localities don't accept this dictate from on high by the federal government, then they will lose federal funding that comes from their tax dollars, along with the tax dollars of other American citizens. The other provision is the somewhat sneakier one, which purports to avoid this direct conflict with the 10th Amendment by establishing a right of state and local officials to participate in the administration of federal laws, which is very strange because, after all, state and local employees report to state and local governments who pay their salaries, and yet this right is apparently unlimited. But in any event, we'll come to that one later. Ms. McBath says, obviously, under all the Supreme Court precedents, you've got to get rid of this Godfather offer because you can't do indirectly what you could not do directly. And I would really recommend that all of our colleagues who still care about Supreme Court case law and interpretation of the Constitution read Justice Alito's opinion in Murphy versus NCAA from 2018. And he points out that the legislative powers granted to Congress are sizable, but they're not unlimited. We are a body of defined enumerated powers, and all powers not expressly delegated to the Congress of the United States are reserved to the states and the people in the 10th Amendment. The anti-commandeering doctrine, writes Justice Alito, simply represents the recognition of this limit on congressional authority for people who are still interested in the original constitutional design. Well, what's the purpose behind the anti-commandeering doctrine? Justice Alito spells it out very finely. First, the rule serves as one of the Constitution's structural protections of liberty. The Constitution does not protect the sovereignty of the states for the benefit just of the states or state governments as abstract political entities. To the contrary, it divides authority between the federal government and the state governments for the protection of individual freedom, the liberty of the people. Second, the anti-commandeering rule promotes political accountability because the local and state officials are elected locally, and they must be responsible to the people, not responsible to Congress or federal bureaucrats who are controlling them. And third, Justice Alito says, the anti-commandeering principle prevents Congress from shifting the cost of federal regulation to the states and localities.
Will the gentleman yield?
By all means.
One of the questions I've got, and I appreciate your summary of the law, I disagree with pieces of it, but this bill is aiming to make it to prevent states from making it illegal from cooperating.
Yes.
Right? There's no compulsion. It just says you cannot decline enforcement. You cannot decline making it illegal to enforce. And as you well know, there are multiple examples of cross-jurisdictional assistances, whether it's drug enforcement, violent crime. So
well, and this is why, thank you, let me answer it, because the Alito decision in Murphy answers precisely your point, because that was the structure of the legislation that was issued there, where the federal law prohibited state authorization of sports gambling. The Congress said, we don't want you to authorize this practice. It's like the sanctuary law. We don't want you to authorize something we disagree with. And the Supreme Court said, even though it doesn't compel an affirmative act by the state or local government, you are interfering with state and local policy when you do that. So I think it will resolve your question completely when you read the Alito decision here. But in any event, that goes to the more subtle point, which we will come to in a moment. I've got something about the 10th Amendment directly. Ms. McBath's amendment is about the very clear point. Okay, so in the Brady Act case, the Congress said all of the sheriffs and local police officers and local government must participate in background checks. And the Supreme Court said you can't compel the state and local governments to use their time that way directly. It would be as if we said, oh, okay, we'll do it indirectly. If you don't accept that system, we're going to cut you off from federal funding. And that's exactly what this does. So
hypothetically, could a state say to a local sheriff, you cannot hand someone over pursuant to a federal detainer? Is that legal under the ranking member's theory?
Good question.
What the states and localities can do is control the conduct of their own officers, and the federal government has the power to enforce the immigration law however it wants. It's got hundreds of billions of dollars. It can do it however it wants.
So you think that the state can make it illegal for a sheriff to hand over an illegal alien?
No, I don't know that any of them are structured that way, but in any event, what they can say is state and local government have the power to control the time and the conduct and the behavior of their employees.
Appreciate the indulgence.
Yeah.
Thank you.
That's exactly what they've done in 11 states, what you just described, what the gentleman from North Carolina just described. The gentleman from Kansas is recognized.
Thank you, Mr. Chairman. And one of the things I love about the Judiciary Committee is that on at least rare occasions, we actually do debate the law, unlike what happens around here so often in this body. And at least in part, this appears to be one of those occasions. I have not joined really any caucuses since I've been here, but I'm thinking about reaching out to some of my Democrat friends with their newfound enthusiasm for the 10th Amendment and think maybe we ought to start a 10th Amendment bipartisan caucus so we can talk about that. During the years I represented the state of Kansas on a lot of federal powers issues, we cited Prince frequently. My client was an amicus in Murphy versus NCAA, and on the unconstitutional conditions issue on the appropriation power, we were a plaintiff in the case that eventually became NFIB versus Sebelius. I was in the courtroom when that was argued. I remember the moment that the Chief Justice leaned forward when arguing counsel for our side, made the point that there had been a letter sent by the then Secretary of HHS to, I believe it was the state of Arizona, I could be mistaken, to a state, clarifying that the language Congress had enacted did not just condition additional funds. This was the Obamacare case, by the way. I'm sure my friend was on the other side of that in terms of what he wanted the outcome to be. But in any event, clarifying that Congress had in fact conditioned the entirety of federal Medicaid funding on a state's decision to expand Medicaid eligibility, not conditioned only the additional portion of funding that would accompany eligibility for what were functionally able-bodied adults without dependents. That was dispositive, and that's what the court held in NFIB versus Sebelius. That's what the court decided, and the language is where's the line between that condition which is coercive versus that condition which just incents voluntary cooperation. I would suggest, as to the amendment that's pending before us, we are nowhere close to that line. As the gentleman from California pointed out in his response earlier, Mr. McClintock, this is not some sort of wide sweeping prohibition on federal funding. It's not even a sweeping prohibition on federal funding for law enforcement activities that goes to states or locals. It is simply saying if we are going to use federal funds to support state and local law enforcement operations, it is reasonable to expect the state and local jurisdictions that receive those funds to not engage in the enforcement of federal law, but to at least not impede the enforcement of federal law, which is what's happening in these 11 states right now. Mr. Chairman, when I served in state office, we had exactly this debate in the state of Kansas. When I was the Attorney General, we had some local jurisdictions, municipalities that adopted safe and welcoming ordinances, local sanctuary ordinances. And I worked with our legislature. We ultimately persuaded them to adopt a state-level preemption statute that forbids our local units of government from having these policies. If the state wanted to, they still could, but our state, in common sense, doesn't want to do that. And I just want to sort of close this argument with this point. You know, I had some very good friends who have a more liberal mindset who were very upset with me after that debate back in 2022 in the state of Kansas. They were big advocates for these local sanctuary ordinances. They'd worked on them in some cases. They were really furious. In fact, one of them, who I'd known for many years, I didn't speak with for a couple of years. I ran into him earlier this year. First time I'd seen him. And we sort of made that sheepish eye contact that says, what's this conversation going to be? And he came over to me and we talked. And we started talking about the federal enforcement actions in Minneapolis, which in my view were righteous in their purpose, but not well constructed until Mr. Homan was sent there by the president to fix the execution. I think things are much better now. We talked about that, and I said to him, hey, you're not going to be, you may not be real happy with me about this, but I want to say something to you, my friend. I said, you know why we haven't seen anything like that in the state of Kansas? And he was silent. I said, because we prevented you from doing what you wanted to do back in '22. If you had gotten to have your way on this sanctuary ordinance, we'd be looking at exactly the same type of federal engagement now.
Will the gentleman yield for a question?
And I will, but let me conclude the point. He was silent for a minute. He looked at me and he said, you know what, Derek? I actually think you're right. I yield for a question.
So I got two quick questions. One is, doesn't your story prove that state and local government can handle this without the heavy hand of Big Brother, the federal government doing it? And two, you imply that the bill has surgically targeted language, but if you look actually on page 6, what it says is it gets rid of the burn grant money, the cops on the beat money, and any other grant administered by the Department of Justice or Homeland Security that's related to law enforcement, which I think is everything, immigration, enforcement of immigration laws, or naturalization. It's a total cutoff of funds, wouldn't you say? I mean,
The time of the gentleman's expired, but the gentleman, if he wants to respond quickly to the question, he can.
Mr. Chairman, I just say on the latter, no, I would disagree with my friend. Of course, the language he just read, although he omitted the word substantially, which is rather relevant here, but of course the language that he just read is connected, but the triggering effect is that language only applies when you have a local jurisdiction or a state that has said we're not going to, that we are going to reserve the right to impede federal law enforcement efforts. So it is narrowly targeted. It's connected to the law enforcement activity. And secondly, with respect to the first point, I would just say this is simply saying immigration is, of course, in general, a federal function. It is constitutionally vested with the federal government. States do not have the authority to impede the federal government from enforcing federal law anywhere within the boundaries of this union, and that is the problem this bill aims to solve.
Gentleman, well said. And the gentleman yields back. The gentlelady from Washington is recognized to speak on the amendment.
Thank you. I just wanted to respond to what the gentleman just said, because not impeding immigration law, immigration enforcement, is not what's happening when a state says, for example, get a judicial warrant. Instead of a detainer, which is just a request, an administrative request, get a judicial warrant, ensure that this is really somebody that should be turned over, because we as a state don't want to be liable for whatever consequences might come and lawsuits might result from turning over somebody who really shouldn't be turned over. That's a federal immigration function. I think the state has a right to say, we want to enforce, we want to make sure that we are only enforcing things that we're not going to be held liable for. So I don't think it's impeding immigration enforcement to say, just go through a process that ensures that we also are protected.
Would the gentleman yield on that?
Yes, though I want to respond to Mr. McClintock as well, so let me do that, and then hopefully I can yield back to you. I'm happy to hear the chair of the Immigration Subcommittee. I think you said that you decry the lawlessness of ICE and CBP in Minnesota. I don't know if that's what you said.
I said I decry the violence that we've seen from the lawless mobs that you folks have been inciting.
Okay, I was going to be so shocked, and thank you for recognizing the lawlessness of ICE and CBP, but I had to check because it seemed maybe not something that you meant to say. Look, I don't know what you're trying to imply in connecting what's happening in Minnesota with the lawlessness of ICE and CBP murdering U.S. citizens, dragging people out of their cars by their hair, locking up people, with no due process. But you did seem to say that if Minnesota, look at some place like Texas, where you wouldn't have lawlessness because Texas is complying with sanctuary laws. And I would just say, and I'm going to enter these into the record in a minute, but Texas prosecutors are losing key witnesses in criminal cases because these folks are getting deported. And there's numerous articles here about this. The DAs in Texas are not able to prosecute murders, crimes of assault, because their witnesses are getting deported. And here's one where this is the DA represents Loving and Reeves counties in Texas. Here's a situation where somebody, an individual was charged with aggravated assault, and then the victim was deported, and this has been a situation that's happened across Texas where people are not able to prosecute crimes because people are continuing to get deported. So I'm going to enter these into the record, Mr. Chairman. This one is from the Texas Tribune. As ICE ramps up deportations, Texas prosecutors say they're losing key witnesses in criminal cases.
Without objection.
Another one is ICE, it looks like that's the same one. This is a situation where you're trying to make an argument that these laws are somehow protecting undocumented immigrants, but you're not recognizing all the things that happen when you deport undocumented immigrants, when you undermine the trust that communities have with law enforcement, and of course the constitutional issues that Ms. McBath's amendment addresses, and I stand in full support of that. And I'll yield to Mr. Raskin, and then I'll yield back to the gentleman in front if you want to.
Yeah, just very quickly, our wonderful colleague from Kansas said that all this is really about is preventing states and localities from impeding immigration law enforcement. The word impede does not appear anywhere in this bill, nor do any of its synonyms that I could find, including stymie, obstruct, handicap, disrupt, encumber, interfere, constrain, and so on. What it does is it invents, for the first time to my knowledge in the history of our country, a right of a local or state official who's elected locally or by the state population and whose salary is paid for by the local government in the state, a right to spend as much time as they want, apparently, enforcing federal law. Again, this goes way beyond what people are talking about in terms of a detainer. And I will quote you the section that I think we need to focus on. What it says is the right of any federal, state, or local government entity or official or other personnel to comply with or enforce the immigration laws. Now, where does the Congress, and I'm happy to turn over to Mr. Schmidt if I've got any time, where does the Congress get the authority to tell a state or local government that its officials have a right to be spending their time enforcing a federal law or mandate?
I yield back.
The gentlelady yields back. We will recognize the gentleman from Wisconsin, and if we can yield some time to, if you have it, we'll yield some time to the gentleman from Kansas. But the gentleman from Wisconsin is recognized.
Yeah, we should have a little time, Mr. Chairman. So yes, I would like to echo this newfound respect for the 10th Amendment. It is truly notable. And the respect for Justice Alito. Yeah. Boy, this is great to hear this. And I would just say to my colleagues on the other side, I hope you share this enthusiasm for the 10th Amendment with my colleagues over in the Natural Resources Committee. It would really be great if that 10th Amendment was emphasized with natural resources in the same way that we're hearing that in the Judiciary Committee.
Will the gentleman yield?
No, I will not. I've got plenty to say here. Since when have we become a country that's going to selectively enforce our laws here in the United States? I mean, that's really, to me, at the heart of this question, because there's real consequences as a result of this. I'd list an example in my home state of Wisconsin. In Prairie du Chien, it was about a year and a half, 2 years ago, a woman was beat to a pulp by a Tren de Aragua gang member. Well, guess where this Tren de Aragua gang member domiciled? He domiciled in Dane County, Wisconsin, a sanctuary county. And that's the threat to people who are in these sanctuary communities, is that someone that wants to commit crime, as this gang member did, he had multiple charges filed against him over the years. They know they can hide out in these sanctuary communities. It threatens the safety of these people. But Mr. Chairman, I would just add this. I think back, let's go in the way back machine 10, 20 years ago. How many times, I sat in the state legislature, how many times did we hear local and state officials say, it's the federal government's job to deal with this immigration problem. They've got to fix it. Well, guess what? Somebody has finally decided to fix it, and now they don't want to support those that have chosen to do something about it. And I want to make an additive comment to my colleague from California, just to my left here. Crime is down 20%, violent crime down 20% last year. And to tell the American people that illegal immigrants commit less crime than Americans flies in the face of that data that we are seeing. What's one of the main things that happened here in 2025 in terms of federal policy? People were removed from this country, especially if you remember what Mr. Holman said. The first people we are going to remove are those who are here illegally but committed violent crimes in their home country or here in the United States of America. Those are the first people that we are going to remove. There is a reason crime is down, and in part, it is because illegal immigrants who have committed violent crime are being removed from our country. I'll yield back.
Will the gentleman yield?
I'll yield back to the chairman here for the balance of my.
Let's, if you're okay, let's let.
I'm happy to yield to Mr.
I'll jump in here in a minute.
Thank you, Mr. Chairman. Just a couple of points in response to my friend, the professor from Maryland. First of all, with respect to the language he pointed to in the detainer section, I believe the way I read that language is, again, it doesn't require or attempt to compel states to enforce federal immigration law. It says that states may not impede their law enforcement officers or locals from enforcing a federal immigration law. And the question was, where does that authority come from? And I would point, for example, to Section 287G, where you may have a voluntary agreement for state law enforcement officers. They have chosen to voluntarily participate in the enforcement of federal law. This would preclude, for example, the state that may have a sanctuary philosophy from precluding a local jurisdiction where a sheriff or others may not have a sanctuary philosophy from participating voluntarily in the enforcement of federal law as Congress has authorized. Secondly, with respect to the thesaurus debate that we were having about the word, what was it, impede, I would point my friend to page 2, lines 20 and 21, where it's defining the types of law enforcement activities that would be protected, can't be prohibited or restricted from participating in federal law. That isn't impede, but it's pretty darn close. I think that's a fair summary. And the final point I'd just make, I guess more with respect to our friend from Washington, look, here's what's going on here. What we are trying to get, as again Mr. Holman has said, I think he has the right philosophy and approach in enforcing this. What we are trying to get is cooperative enforcement, where all the good guys are on the same page, pulling the same way. And you don't have local politicians telling local law enforcement officers, you may not cooperate with your federal brethren. We want to leave that judgment to our good local law enforcement officers who can balance out when is the right time to cooperate and when is the right time to give more weight to, for example, the effect on the local community. They may know that best, but certainly the folks in the local political circles don't, and it is proper for us to say that. I would yield back.
Mr. Chairman, I yield back.
Gentleman yields back. The chair now recognizes, who seeks recognition? Gentleman from California is recognized.
This gentleman?
That gentleman, yeah.
Thank you, Mr. Chairman.
The gentleman is definitely a gentleman, yeah.
Just wanted to talk about a little bit about all good guys working on the same side. Like I said yesterday, Orange County, small little county in California, sanctuary state. Like I said yesterday, last year, ICE detainers, 323 individuals referred to ICE. 52 of them were never picked up. So I think what's important to do is make sure that we're taking care of business, where we talk about not cooperating with federal enforcement. And these are the worst of the worst. My local sheriff, Barnes, has said, it's a one-way street. Feds don't cooperate with me, don't call me when they're doing operations. Very frustrating. But, you know, let's really talk about sovereignty, state rights. Look, federal government hasn't addressed immigration reform for what, 40 years? Last one was that great Californian Ronald Reagan that did something. So states have taken upon themselves, like California, to address immigration reform. And it's really a selfish thing we do because we're protecting our economic interests in the state of California. We're the fourth largest economy in the world. We are the biggest ag state in the union. We're the biggest light manufacturer in the union. We're the biggest venture capital state in the union, 65%. We lead the nation in bio, chip manufacturing. And these are all sectors that have a lot of immigrants working. If this country wanted to lead the state's immigration reform, and to my colleague, Mr. Tiffany from Wisconsin, last I looked, 90% of the dairy workers at dairy farms in Wisconsin were undocumented. So let's really lead and fix the problem. That's really what we're talking about right now, is undocumented immigration in this country. They're not all criminals. Those that are should be taken care of. Move on. Don't need you here. But those that are hard workers, we are not addressing. And I can tell you right now, home manufacturers, home builders in this country, deep south, I know right now are pissed because they can't deliver their products on time, and they're going to be asking you for a solution, which all of us should come up with. So, but I got to tell you, I have an even better solution to the issue of undocumented. Instead of trying to run up all these folks, go after the employers. Pass E-Verify. Put major penalties on the employers. You're going to see those jobs disappear. Our economy is going to shrink, absolutely. We're going to lose a lot of economic muscle, but as a nation, we have to decide who we are. Do we want to be a strong economic nation, or do we want to just be another Japan and go about that route? So, folks, willing to work with you on these solutions, but again, sovereignty, state of California, trying to do what's good for Californians. And by the way, ladies and gentlemen, we pay $80 billion more per year to the federal government than we get back. So you know what we can do? We can also cut a deal here, which is you stop taking our federal dollars, leave us alone, and we won't take the federal money that the federal government gives us. We'll be $80 billion ahead of the curve. But when you talk about economic growth, that means paying federal taxes. That means being the fourth largest economy within the largest economy in the world. That's what it's about. My ranking member, did you want to have some comments? You wanted
Well,
some
I was gripped actually by your remarks. I mean, that was a very powerful argument, and I thank you for making it. I wanted to reply to my friend, the former Attorney General of Kansas. Again, the bill is being characterized as preventing the impeding of federal immigration law enforcement. What you quoted back to me was about what shall not be prohibited or in any way restricted was the right of a state or local government employee who reports to a different part of the government to be enforcing a federal law. But I don't understand where that right comes from. If it's a constitutional right, you don't need this bill. They can just go sue. Of course, it's not constitutional. We're creating for the first time a federal statutory right of a local government employee not to be following their orders for what they should be working on in their time, and instead working to enforce a federal mandate. And if it can be done for this, it can be done just as much for gun control and background checks.
Gentleman's time has expired. The gentleman from North Carolina is recognized.
Thank you, Mr. Chairman. Just briefly, Mr. Raskin, and I'll be happy to yield to Mr. Schmidt as well, but should states have the authority to make compliance with detainers illegal?
Illegal, like a crime to do that? No.
That's what sanctuary...
In other words, I don't think it can... First of all, you got to explain to me what you mean comply with the detainer. Because I understand what's been happening in a lot of these cases is the local government is being asked to hold somebody beyond their stay in prison. They've been sued for that, and they're saying, we cannot take the liability.
That's not uniform. I'm just saying, in certain states, I'm not trying to be petulant, I just want to get down to the issue, but can a state preclude local law enforcement or local sovereigns from honoring federal detainers?
Again, but you've got to give me the specific example of what you mean from when you say honoring a federal detainer.
Hypothetically, let's say...
So, I mean, if the federal government is saying, we're going to come pick somebody up while they're still, their term of...
Yes,
is still...
within the parameter.
Within their term? Then I would say that I think that is very much at the edge, if not over the edge. But do you think that the federal government can compel a state or local government to hold somebody beyond their term in potential violation of due process in order to hand them over to the federal government, because that's what they're saying on the other side, again, on the detainer issue, which I think is a small part of this.
Well, the sanctuary jurisdictions that I have the most concern with is they preclude any adherence to detainers. They make it illegal for local sovereigns to engage with federal immigration at any level. And they are precluded from keeping people who are lawfully arrested under state law, from keeping them in custody.
Yes.
And then holding them for law enforcement at the federal level.
All right, well, I have profound policy problems with that, and constitutionally, I would think that the federal government, if, for example, if a local government were to say, we're gonna let somebody out of jail early in order to escape the federal government, I think that would raise profound problems. But this legislation goes way beyond that. What it's saying is that every local government employee in the country essentially works for ICE now and works for Homeland Security. And again, if you can do it for ICE and Homeland Security, you can do it for the ATF and the FBI with respect to background checks.
Well, reasonable minds can differ about the language, but the issue that I have, again, is the preclusion of any cooperation with federal law enforcement. And Mr. Schmidt, if you
if the gentleman, just for a second, I believe that's exactly the situation that exists in the counties. I'm seeing, we're not taking public testimony today, but that's exactly the situation that exists with these local law enforcement people in the state of Maryland. They want to, they had the agreement, and the state said, no, you can't.
My colleague from Kansas, do you wish the remainder of my time?
Sure, I would thank you.
I'm happy to yield it to you.
Thank you. I appreciate the gentleman from North Carolina. And just,
thank you, Mr. Raskin. Thank you.
We are marking up a bill, so not to get too far down in the weeds, but to stay on that spirit. I believe, Mr. Chairman, the current state of play is we are on the amendment from the gentleman from Georgia, which does not relate directly to the anti-commandeering arguments. It does relate to the unconstitutional condition arguments. And with respect to the linkage that my friend from Maryland talked about, I would point into page 5, line 14, for example, which is in the language to be stricken by the Georgia amendment. That ties the condition on funds back to subsection A or subsection B, which is where the language is we've been talking. So they are connected. It's not one or the other. And I think it's permissible for the reasons we've already talked about. I don't know if that's satisfactory to my friend, but at least that's where we're disagreeing.
It's illuminating nonetheless. Yeah.
Thank you, Mr. Chairman. I would yield to whoever I should yield to.
I think the time belongs in. Can the gentleman yield to me? I appreciate it. I just wanted to try to get his focus back on, I mean, I appreciate all the arguments here, and I think they are important, but I think when the sponsor of the amendment first offered the amendment, she talked about bullying states. She said that this would make it worse. This is designed to make it better. And what we heard yesterday was 17,864 times in 1 year in sanctuary jurisdictions, a detainer was filed while that illegal migrant was in custody, charged with some other crime, and that individual was released. And remember, that only applies to a third of the country, because 2/3 of the country, someone else said that this, most of the country, I think Mr. Tippett saying most of the country doesn't want this. Most of the country doesn't have to deal with this, because most of the country honors these things. But in a third of the country, 17,864 times those detainers were not honored, and the guy who should have been turned over to ICE was released, and many times went out and harmed someone. That is what this is focused on. As the gentleman from Kansas said, as the sponsor said, that is the focus, and if we can pass this, I think we can make a real difference. Gentleman from North Carolina is not here, but I know he yields back. Question occurs on the amendment offered by the gentleman from
Word quickly.
Okay, gentleman from Wisconsin is recognized.
Thank you. I mean, the 10th Amendment, and as we are referring directly to the amendment, I mean, it still comes back that within the 10th Amendment, it still says immigration is treated as a federal power because it relates to foreign policy or national borders or international relations. So I think that's kind of being lost as to why the discussion over the 10th Amendment, to me, it doesn't make much sense, because it clearly is something that the federal government has been given the responsibility to handle across all 50 states and territories. And Mr. Biggs may remember, because as recently as 2012, Supreme Court did take up Arizona versus United States. And in that instance, what was argued was that there were certain parts of that Arizona statute that were admissible and were okay as a result of the 10th Amendment, and other parts that were struck down because of Arizona's immigration law. It clearly interfered with federal authority. So I don't, the bright line I don't think exists as we're kind of laying it out there today. So, what I would say is you can't, they can ignore the federal government, municipalities, like the city of Madison. They don't call it sanctuary city, they call themselves an open and welcoming city. So they just have redefined sanctuary city and include in that they're not holding people in jail solely for immigration authorities unless there is a warrant. They're not asking about immigration status when there's an arrest. They're not using local resources to enforce federal immigration law. And it's limited information sharing with immigration officials. It's not a give and take kind of dialogue that's happening. So I guess what I would say in regards to the amendment is you can't have it both ways. They can ignore the federal government and just not do anything. But this is an elected body that went as far to pass ordinances in this case. But they can organize and legislate to kind of prevent this municipality from participating. But it still falls down to the federal government. We have a responsibility to make sure that this works. And if we're simply going to say, listen, this is not something that the states need to be concerned about, it just doesn't make any sense to me. And that's why I think you should vote no on this amendment.
Well, would the gentleman yield?
I do.
I just wanted to respond to something that we heard from the Democrats. The gentlelady from Washington, I think, said it best. Sanctuaries are not impeding enforcement. They're simply not cooperating with enforcement. Well, if they're not cooperating with law enforcement, why are we giving them law enforcement funds? Do the Democrats contend that the federal government no longer has the authority to condition the use of federal funds provided to the states? Highway funds, for example. Do the Democrats contend that a state now has a right to refuse to enforce federal transportation regulations and still qualify to receive federal highway funds? Are universities now free to accept federal funds while they ignore Title IX? Remember, they wouldn't be impeding Title IX, they just wouldn't be enforcing it. And how about Medicaid funds? Can states now spend those funds while ignoring the laws that regulate the use of those funds? This is absurd. And it seems confusing at first because it's so manifestly contradictory with the position that the Democrats have taken in the past, but it shouldn't be confusing because there is one consistent theme that runs through all of these legal contortions. The Democrats do not want criminal illegal aliens deported from this country. They want them returned to our neighborhoods. There should be no confusion once you understand that simple fact. Their position then becomes entirely consistent. I yield back.
I yield back, Chairman.
Question occurs on the amendment offered by the gentlelady from Georgia. All those in favor say aye. All those in favor, or all those opposed say no. No. In the opinion of the chair, the noes have it.
Roll call vote, please, Mr. Chairman.
Roll call, but that was clear. Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Massey votes no. Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Nels votes no. Mr. Moore? Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Baumgartner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Cohen votes aye. Mr. Johnson? Mr. Swallow? Mr. Liu? Ms. Jayapal. Ms. Jayapal votes aye. Mr. Correa. Ms. Scanlon. Ms. Scanlon votes aye. Mr. Neguse. Ms. McBath. Ms. McBath votes aye. Ms. Ross. Ms. Ross votes aye. Ms. Ballant. Ms. Ballant votes aye. Mr. Garcia. Ms. Kamlager-Dove. Mr. Moskowitz. Mr. Goldman. Ms. Crockett. Mr. Klein votes no. Mr. Gooden votes no.
Gentleman from Washington.
Mr. Baumgartner votes no.
Gentleman from California.
Mr. Issa, you're not recorded. Mr. Issa votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 17 noes.
The amendment is not agreed to. Who seeks recognition? Gentleman from Maryland is recognized.
Thank you, Mr. Chairman. I've got an amendment at the desk.
Clerk will report. Point of order reserved by the gentleman from Arizona.
Amendment to the amendment in the
Without
nature.
objection, the amendment will be considered as read. The gentleman from Maryland, the ranking member, is recognized to explain the amendment.
Well, thank you very kindly, Mr. Chairman. I'm delighted that we've had some meaningful 10th Amendment discussion today, and I want to thank Mr. Knott and Mr. Schmidt especially for their illuminating comments. I think that's the crux of the entire issue we're looking at here today, and I've appreciated various members' contributions on both sides. I didn't appreciate the sarcasm about a newfound 10th Amendment caucus, just speaking for myself, but I'm sure there are a lot of other Democrats on this side who can relate to this. I was a state senator for 10 years. I worked in state and local government for decades. I believe very strongly in state and local government, and I also try to be consistent in my defense of every part of the Constitution. So some people have noticed a newfound respect for the First Amendment in certain cases, but not in others by some of our members. But I've never engaged in sarcastic jibes about the new First Amendment caucus from people who never had ACLU Hero of the Year awards given to them. I think that we should be encouraging everybody to support every part of the Constitution, and we could have a meaningful debate about it. And that's what we should be working on. What does the Constitution actually mean? So here's an amendment that I think can unify the entire committee, because everybody here is swearing fealty to the 10th Amendment. And so that's all that this amendment does. It adds to page 2, line 7, the following language, which relates to this newly created right of local and state officials to enforce immigration laws, even in their capacity as state and local officials, simply to say, except that such right does not include the authority to cause any federal, state, or local government entity, official, or other personnel to conduct themselves in a manner that is inconsistent with the 10th Amendment to the Constitution. So it simply says, in the process of creating this new right, we cannot be violating the 10th Commandment, which is a statement that the anti-commandeering principle still obtains. Now, my distinguished friend from Wisconsin, Mr. Fitzgerald, I think he asked the question, well, if Congress has the power and the authority over immigration, then we occupy the entire field, we can do whatever we want. That was precisely the view that was rejected by the Supreme Court in the Prince decision, in U.S. versus New York, in the New Jersey case, because the court said, yes, Congress can do whatever it wants, it can regulate the individual citizens of America and create policies, but it cannot conscript the state and local governments and their officials and their bureaucratic apparatus to work for the federal government. And so all this amendment says is, okay, you're creating this new right, that right has to be interpreted consistent with the 10th Amendment to the Constitution as it's been spelled out by the Supreme Court in these cases. So I render that to the wisdom of the committee, Mr. Chairman.
The gentleman yields back. The gentleman from California, Mr. McClintock, is recognized.
Oh, Mr. Speaker, or Mr.
Oh,
Chairman.
wait, hang on one second, if you would. The gentleman from Arizona withdraws his point of order. Gentleman from California then is recognized.
Mr. Chairman, with all due respect, this is absurd. The 10th Amendment is supreme. And simply restating it in the legislation is superfluous. We're quite confident that it's entirely consistent with the 10th Amendment. By the way, it's also consistent with Article 1 and the powers of Congress. Should we also have a provision that says that nothing shall be inconsistent with Article 1? And while we're at it, let's throw in the presidency in Article 2 and so forth. This is simply an absurdity. Again, there is one consistent principle that goes throughout
Could you say the whole
Democrats'
Constitution?
Opposition.
Gentleman yields back. Or, excuse me, does the gentleman yield to, gentleman yields to the gentleman from Missouri is now recognized.
Thank you. Yes, I believe, obviously, every one of our statutes has to be consistent with the 10th Amendment as well as the 9th, 8th, 7th, and so on. But I think this new caucus with the Democrats' defense of sanctuary jurisdictions should not be called the 10th Amendment caucus. It should be called the Nullification Caucus, perhaps the John C. Calhoun Caucus. I yield back.
Gentleman yields back.
Would
to
the
gentleman from
gentleman further yield? Would you further yield? I'd like to pile on for the distinguished professor and ranking member. What he proposes to do, if done for our national defense in a direct way, would mean that if in fact troops landed in Florida or Texas or California, once they were in Florida, Texas, or California, or Arizona, well, the state could decide not to participate in or facilitate any kind of action that would allow our military to know the position of the enemy. Because, of course, you can't conscript them. That's ridiculous. We are under attack every day by criminals. And all that the chairman is asking for, all that we are asking for, is that they not hinder and, in fact, at least participate in the sense of, when given notice, to not release through the back door criminal aliens and the like. And yet the chairman would have, or the ranking member would have us believe that somehow that we're out of line with the 10th Amendment. The 10th Amendment never included the Civil War, that the states had the rights to simply say to the federal government, no, we're going to have slavery when you say no, we're going to do this when you say no, because we have the 10th Amendment. The 10th Amendment does not invalidate constitutional responsibilities or the responsibilities of the states to observe the Constitution. Would the ranking member even begin to say that somehow segregation is okay if it's okay in the states, that other activities that are barred and interpreted by the Constitution somehow don't apply to states, and that, in fact, somebody adjudicated by the federal government for removal from the U.S. because after their consideration they are illegal or their applications have been denied, that somehow it's okay? Would the ranking member think that when you show up in the California border that, in fact, it's okay, since you're in California, for the California authorities to say, well, come through this door, don't worry about the customs people. Yeah, they're telling you can't come in the country, but you can come through here. Because that's exactly what happened under the Biden administration. That is what this administration is bringing to a halt. And the idea that you're going to use the 10th Amendment as a sword hung over every federal officer is absurd to the max. And with that, I thank the gentleman for yielding and yield back.
My pleasure, and I'd simply direct to the Democrats' attention Andrew Jackson's proclamation to the people of South Carolina. The last time the Democrats propounded the doctrine of nullification, he pointed out it was incompatible with the existence of the Union and would lead to its destruction. They lit the fuse for the Civil War with that doctrine. We buried it with the Confederacy, and now here it is back again. I yield back.
Gentleman yields back. Question, gentleman from Washington. You'd have to yield time. It's someone to yield time if you got something. If not, I'll recognize the gentleman from Washington. Come back. Lady from California is recognized.
Thank you very much, Ms. Jayapal. I just wanted to respond to some of the trenchant remarks by members of our new GOP pro-union, pro-civil rights movement anti-Stonewall Jackson, anti-Confederacy caucus. That's great, and I'm glad to see the emergence of this new anti-Confederate caucus on the GOP side today. The members continue to abstract from the actual language of their bill. We know that they want to engage in attacks on sanctuary cities. Their bill goes way, way beyond that. What it says, it creates, for the very first time to my knowledge, and I would love to be corrected if there's another legislation that works like this, it creates for the first time a right of state and local government officials to participate in the enforcement of a federal law. And the closest thing to that is the Prince case. I wonder whether there are any of my colleagues who disagree with Justice Scalia's decision in the Prince case, which said no, that state and local officials could not be asked to participate in the background check process, even though the government's testimony was it would just take a few minutes. It would just take a few minutes out of their time, and Justice Scalia said you can't do that. These people work for the state government or the local government, and nobody seems to want to actually wrestle with what's really in the bill. We know you hate sanctuary cities, and I'm sure there's a lot of other state and local policies you hate, and I'm sure there are a lot of state and local policies that are hated by people on this side of the aisle. That's not the question. The question is whether this is constitutional for us as Congress to adopt a procedure where we're telling state and local officials, sheriffs, chiefs of police, police officers, firefighters, anybody else, that they have a right to spend their time working on federal priorities, whether that's the enforcement of gun safety laws by ATF or enforcement of policies under ICE. And nobody seems to want to deal with that. And everybody suddenly wants to make fun of the 10th Amendment like it's not a big deal. Read Justice Alito's opinion about the central importance of the 10th Amendment to the freedom and the liberty of people in the country.
Will the gentleman yield?
Yes, by all means.
Forgive me if I'm not as sharp as I should be on that case, but I believe that Scalia's issue in that case was the compulsion. The federal government cannot compel state actors to carry out federal function. But what we're trying to achieve is the voluntary assistance. And take immigration out of the context. When I was prosecuting cases, we used local law enforcement all the time in federal investigations, whether it was drug trafficking, firearms trafficking, humans, whatever. And relying on their expertise, their actions, that's more in line with what we're trying to codify here. Right, that states cannot preclude local actors from voluntarily engaging with federal law enforcement.
Okay, so reclaiming my time here.
Yes.
Under the 287G program, right now, it's perfectly possible for any state or locality that wants to participate in this to do it, as you well know. The question is, must they be compelled to do it, or put differently, according to the language of this bill, does a state or local government...
The gentleman yield?
Yeah.
Well, you said it's perfectly proper for them to do it now, and they can do it now, except in your state. My understanding, I just talked to some of the sheriffs from your great state, and they said they are being prohibited by their state from engaging in the 287G.
But that's American federalism, Mr. Chairman, as you understand.
Well, you just said that they can do it if they want. The locality can do it if they want. I'm saying in your state they can't because the state's coming after them, and we want to say you should be able to do that under our law.
The localities, as you know, under American federalism, and the Supreme Court case law is perfectly clear on this, report to the state governments. The state governments create the municipalities. So some states want to participate, some don't. And then some say it's up to the municipalities and some don't. That's a question of federalism. And I've not opined on what my personal policy position is on this at all.
So
despite all of the attacks I'm drawing from my friends. Well, I'm saying constitutionally, we can't do this.
So extrapolating that, if a sheriff's deputy arrests an American citizen with a trunk load of methamphetamine, is that unable to be prosecuted federally?
Of course that can be prosecuted federally.
So that's cooperation with the local law enforcement at a state level that's prosecuted or handled federally. So why can't that be extended in this context with the enforcement of immigration laws?
Oh, it certainly can be if what you're saying is that localities or states can make the decision to participate in the 287G agreements, as many do.
But they're precluded from doing so in sanctuary jurisdictions. That's the problem that I have with it.
Well, and this is why I come back to the Prince decision and the other anti-commandeering decisions of the Supreme Court, which says that the states retain their power over their own resources, their own taxes, and their own employees. And that's all that these people are saying. And if anybody's violating federal law, then prosecute them for it. If they violate federal law, they should be prosecuted.
Question occurs on the amendment offered. Oh, I'm sorry. That's right. I knew there was someone else, but it wasn't written on my list. I've not forgotten. Briefly forgot. The gentleman from Washington is recognized.
That's a safe bet, Mr. Baumgartner.
Thank you. And I will be brief. I am enjoying this conversation and certainly leave it to my guest colleagues to explain why the ranking member is wrong. And I have a lot of respect for the ranking member's positions as intelligence. I just do want to make one comment about sarcasm. You attack the use of sarcasm on our side to illustrate this point. I've been on this committee now for 14 months, and I've heard you use sarcasm and use it well several times, even today, and that's okay. Because,
using it and using it well are two different things.
Let me just conclude by saying it was Oscar Wilde that said sarcasm is oftentimes the lowest form of wit, but the highest form of intelligence.
Yeah.
So, and with that, I yield.
He attacked sarcasm with sarcasm, and his amendment is now the question before us. All those in favor of the amendment offered by the gentleman from Maryland say aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it.
Can I seek a recorded vote, please, Mr. Chairman?
Recorded vote being requested, the clerk will call the roll.
On the 10th Amendment.
Mr. Jordan?
On the amendment offered by the gentleman who used sarcasm. No.
Mr. Jordan votes no. Mr. Issa?
No.
Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Van Drew? Mr. Nels? Mr. Moore? Mr. Moore votes no. Mr. Kiley? Mr. Kiley votes no. Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Onder? No. Mr. Onder votes no. Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Harris, you're not recorded. Mr. Harris votes no. Ms. McBath, you are not recorded. Ms. McBath votes yes. Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 9 ayes and 16 noes.
The amendment is not agreed to. Who seeks recognition? The gentlelady from Washington is recognized.
Mr. Chairman, I have an amendment at the desk.
Clerk report.
I reserve.
Point of order reserved by the gentleman from California.
Amendment to the amendment in the nature of a substitute.
Without objection, the amendment will be considered as read. The gentlelady from Washington is recognized to explain the amendment.
Thank you, Mr. Chairman. My amendment would ensure that states and localities have access to essential funds and grant programs to combat human trafficking, domestic violence, sexual assault, and sexual abuse, regardless of their policies on immigration enforcement, which is ultimately the responsibility of the federal government. The idea that we would deprive state and local governments access to these important funds is unfathomable to me. There are many reasons why state and local governments don't want to work with ICE. We've seen just this past year how cooperation can impact the willingness of immigrant communities to report crimes. I entered into the record some articles from Texas. In Utah, a man set his house on fire, killing himself, his partner, and their children. His partner's family said she kept silent about the abuse that she had suffered at his hands because she was afraid of being deported. In Tennessee, the number of victims seeking help from police department's Family Safety Center dropped 91% between April 2025 and July 2025 after the Tennessee Highway Patrol began cooperating with the ICE surge in Nashville. There was a time when supporting victims of sexual assault and violence was something that both parties agreed on. The initial iteration of the Violence Against Women Act passed the House by voice vote, something that is hard to imagine today. It reshaped how we talk about gender-based violence and how we treat survivors. Human trafficking, a multi-billion-dollar industry that includes both sex trafficking and labor trafficking, occurs in all 50 states. Labor trafficking, sex trafficking, and the proliferation of child sexual abuse material and crimes ranging from harassment to sexual exploitation are some of the most depraved crimes that can be committed against another person. Perpetrators of these crimes prey especially on vulnerable populations, particularly children, at-risk youth, and members of marginalized communities. For nearly 25 years, our government has been a global champion to eradicate human trafficking domestically and internationally. We rely on a national network of 61 task forces that represent over 5,400 local, state, and federal enforcement and prosecutorial agencies. These dedicated professionals prosecute criminals that exploit or traffic people, and they prioritize identifying and rescuing victims. Without this collaboration, investigations and prosecutions could come to a halt, empowering abusers and condemning victims to continued abuse. Sadly, this bill wants to take all this assistance and more away from states that do not want to be complicit in the Trump administration's immigration schemes. I think of it as pure legislative blackmail. But I guess I shouldn't be surprised because it's coming from a Republican Party today that seems hell-bent on protecting perpetrators of sexual violence. While this administration claims it's going after the worst of the worst on immigration enforcement, according to recent data obtained by CBS News, only 1.4% of all the people arrested by ICE were related to sexual assault, and 70% have no conviction. Let's compare that to President Trump and his cabinet. Between President Trump, Pete Hegseth, RFK Jr., and Howard Lutnick, a whopping 24% of the president's cabinet have been credibly accused of sexual assault or have visited Epstein's island. Or let's look at how the Republican Party has dealt with Jeffrey Epstein. The president and the Republican majority did everything they could to stop the bipartisan discharge petition from Representatives Massey and Khanna to demand that all the files be released. And once they failed, they all pretended that they were for it and voted yes. But then the Department of Justice dragged its feet on releasing all the files as they were required to do by law. And when DOJ finally released the files, they exposed the names of dozens of survivors without redaction while maintaining redaction for the names of perpetrators. Not only did DOJ disclose survivors' names, DOJ released their emails, addresses, and nude photos. Names released even included Jane Doe's, who had been protected for decades. Some survivors' families found out for the first time that they had been trafficked by Epstein, thanks to DOJ's sloppy work. In other countries, we are seeing consequences. A former prince, an ambassador arrested for their crimes related to Epstein, and a former prime minister charged with gross corruption. But here, no new charges have been filed. We've had no hearings on any of this in the Judiciary Committee, and we're seeing files continue to be redacted and removed from the Department of Justice's website just because they seem to have statements that talk about Donald Trump. Now, this doesn't have to be the end of the story. This is one small way that we can show that we still support survivors of sexual assault and violence.
Regular order.
And we can accept this amendment to ensure that we are doing everything possible to end violence against women. I yield back.
Gentlelady yields back.
I withdraw my reserve, but seek recognition.
Point of order is withdrawn, and we'll go first to Representative McClintock from California is recognized.
Thank you, Mr. Chairman. The hypocrisy is astounding. Violence against women, sex and labor trafficking, these are the very fruits of the Democrat sanctuary policies. They enticed hundreds of thousands of unaccompanied minors into the country. They trafficked them then to unvetted or poorly vetted sponsors and then lost track of them as these kids disappeared into this dark underworld of sex and labor trafficking. Their sanctuary policies are the foundation of these atrocities. Sadly, there are thousands of examples to choose from, but let's just drill down on one. Marvin Fernando Morales Ortiz. He entered the United States in 2016 and was released into the U.S. by the Obama administration. After living in the country for 6 years, the Biden-Harris administration dismissed his immigration proceedings in 2022, one of roughly 1 million quiet amnesty cases under the last administration. That dismissal came after a far-left prosecutor dropped murder charges against Morales Ortiz related to a 2019 murder. Predictably, that wasn't his last run-in with law enforcement. His rap sheet includes arrests for aggravated assaults of a police officer, larceny, disorderly conduct. In September of 2025 in Fairfax County, Virginia, just a few miles from here, he was again arrested for assaulting and brandishing a firearm. If you thought that would finally result in some well-earned time behind bars for Morales Ortiz, you'd be wrong. Instead, yet again, the Democrat prosecutor dropped charges against him, and yet again, the local sheriff refused to honor an ICE detainer and failed to notify ICE that he was being released to Northern Virginia communities. The results were predictable: another dead American. Marvin Fernando Morales Ortiz is the portrait of everything that's wrong with the Democrats' lawless, open borders, pro-illegal alien, soft-on-crime policies. Every step of the way, Democrat elected officials failed the American people, all to benefit an alleged MS-13 gang member and murderer. That is the consequence of sanctuary policies, and that's why we're here today to address them.
Would the gentleman yield?
And I yield to the gentleman from California.
You know, the gentlelady many years ago, when she entered this committee, made statements that I called naive, and she chastised me as somehow not respecting her as a woman. Today, she wants to make every issue, again, like a woman's issue. I championed and voted for the reauthorization of violence against women, worked directly with the then Vice President. The reality is, you are conflating two very different programs. Historically, and I will forget that you've been here so long now, and say, sanctuary used to be, don't ask, don't tell when someone's a victim. When police go to a crime scene, they don't ask somebody if they're legal or illegal, just the opposite. They treat everyone as potential witnesses, and they do everything to make sure that they can give appropriate testimony. And the federal government has respected that where it existed. Currently, sanctuary cities is all about protecting illegals deliberately and when they know they are, and particularly in my home state, putting criminals back on the street after they have been convicted of crimes, after they are known to be dangerous. Because they're illegal, they slip them out the back door and deny federal agents the opportunity to, even when they've been ordered deported by an Article I judge. So today, I would say, you need to realize that after all these years, it's not that you're not smart, it's not that you're not well educated, you simply know things that aren't true, and I yield back.
Well, thank you so much for mansplaining to me, Representative Issa.
And that was exactly the term
right.
you
Listen,
loved to use a decade ago.
I have never used that term before.
I'll find it in the record. Thank you very much.
I think what you said is absolutely outrageous.
The committee will be in order. The time belongs to the gentleman, Mr. McClintock from California.
And I yield back.
And the gentleman yields back. Who seeks recognition? The ranking member seeks recognition.
And I yield to the gentlelady from Washington State.
Thank you so much. First of all, 172 Republicans voted against the reauthorization of the Violence Against Women Act in 2021. Everything I said about the Epstein files is 100% true. Republicans did everything they could, with the exception of Mr. Massey and a few women on the other side, to stop the release of the Epstein files. So to have you try to mansplain to me, that's the first time I've used it in this
Check the record,
committee.
it's not true.
The first time I've used it in this committee, and if I used it before, because I actually don't remember, I do remember you calling me naive, and I remember that it was a remarkable criticism from somebody who I think should know much better. Maybe I should call you naive back. But all I can say to you, Mr. Issa, is that it is absolutely a fact in this country that sexual assault and violence against women have not been taken seriously in way too many ways. The Epstein file, the reason that is resonating so strongly across the country is because the depravity of predators and pedophiles that is demonstrated in the files of men objectifying women in every possible way, of the way in which survivors have absolutely been dismissed, told to shut up, told to move on. And if you want to argue that that somehow doesn't relate to the Violence Against Women Act and the fact that Republicans voted against it, and now you want to take away money from states that are trying to implement domestic violence prosecutions, you are missing the point. You are really missing the point. And the reality is that there are women across this country who are going to watch this hearing, and they are going to see that the things that you just said are exactly the reason why we're still not prosecuting these predators and pedophiles. Exactly the reason why, when those survivors stood up here and Pam Bondi turned away and refused to apologize, not a single person on your side other than Mr. Massey, and I think Mr. Roy actually did speak to the Epstein victims as well, not a single one of you were willing to say anything about this. So don't go telling me that I am conflating issues. Your side needs to take this seriously and stop taking away federal funds from local and state governments that are trying to prosecute these assaults against women, violence against women, because without those federal funds, we have very little funding to do this kind of work at the local and state level. So thank you for mansplaining to me. It didn't work. It never will work. And you, I think, should think about how you actually are going to stand up and protect survivors and victims of sexual assault.
When I'm reclaiming my time, Ms. Jayapal, I am proud of the extraordinary work you've done on behalf of the victims in the Epstein case, as well as for women and girls and all victims of sexual violence and assault ever since you got into Congress. And I would much prefer to be naive and idealistic than to be jaded and cynical at this point in our careers. We could use a little more idealism in our politics. Let me just go back to the basic point about the shakedown of the state and local governments. Mr. Knott asked me, I think, a trenchant question. Mr. Knott, I'm responding to you, if that's all right. I'm coming back to you. It seems to me that it would be fine, again, this legislation is so sprawling and comprehensive, it goes way beyond the whole detainer issue, but I started thinking about your detainer question. I think it would be absolutely fine to pass something saying that state and local governments have to notify the federal government before somebody's released from jail or a prison sentence. And then the notification then gives the federal government the perfect opportunity to enforce their system. And again, we're talking about billions and billions of dollars compared to, the measly millions or thousands that most of our localities have. But why do we have to pass a law saying that every state and local employee in America somehow has a right to be enforcing federal laws, federal immigration laws? That makes no sense to me. I think it's incoherent in our system, and it totally collides with what the Supreme Court said. By all means.
Well, that's exactly what's happening. They are notifying sanctuary jurisdictions to give us a heads up, notify us if you're going to let this guy out, and they aren't doing it because they're a sanctuary. That is the whole point.
If that were your bill, I would support it. If your bill would simply say there's a notification requirement for all state and local governments, I will be the first Democrat to sign onto your bill.
Well, legitimate yield?
Yes.
Doesn't that kind of violate the principle, though, of keeping the federal government from compulsory action?
I don't think so, and that was what I was thinking about, but I don't think it does. It's
Gentleman's
very.
time has expired.
Okay.
I'll recognize Mr. Knott to continue the dialogue. The gentleman from North Carolina is recognized.
But again, the issue that I have is just it's the preclusion of voluntary association with federal law enforcement for federal issues. Like I use the drug crime, like I use with if someone's arrested who happens to be illegal, in certain sanctuary jurisdictions, local law enforcement is precluded from any engagement whatsoever. And that's the sanctuary problem, the sanctuary policies that we're trying to address here.
Well, would you yield just for
Absolutely.
1 second? I know that our good chairman was upset about different things the FBI was doing in the last administration. And let's assume, arguendo, he was right about those. Let's say there was a memo which I think was disappeared after 20 minutes. But anyway, he loves to talk about this memo about going after parents at school board meetings, whatever. If a local school board or city said, we will not participate in investigation or prosecution of parents for exercising their First Amendment rights, are you saying that we could pass a law compelling them to do that?
No, I don't think that's apples to apples, though.
Why?
Well, if someone's here illegally in state custody, that's different than a parent who's showing up at a school board meeting, right?
No, the question goes to our control of state and local government officials.
Again, what you're saying, I agree with you. That is compelling state action, which is different from precluding voluntary action from local officials.
That's why you got to read the New Jersey case, because that's precisely what Justice Alito rejected, that distinction.
Gentleman yield?
I'm happy to.
Well, but I thought you said you were for compelling local authorities to notify the federal government. You just said you were for
I'll explain why.
Compelling that aspect, but nothing else.
I'll explain
he's
why.
Talking about voluntary.
Well, but I'd love to explain why, if it's okay with the gentleman.
Well,
I think a notification requirement is completely different. I think that's absolutely de minimis, and that's something that I think is the play within the joints of federalism. But that is a galaxy away from saying that official can spend whatever time he or she wants enforcing federal laws. And remember, it's not just immigration. I know everybody on your side wants to enforce the immigration laws under, Secretary Noem, but we could flip it around and say, well, now we're going to enforce the ATF laws or the FBI laws by giving them the right to participate with us.
What about an amendment that would preclude local lawmakers from making voluntary cooperation illegal? Would you support that?
You say voluntary cooperation. Do you mean as a citizen or as a paid public official reporting to duty? But see, what is the limiting principle on that? You guys want to create a right of a local government official to cooperate or to enforce federal laws. Can they do it 20 hours a week, 30 hours a week? How about 40 hours a week?
I would say to answer that with illegal immigration, it depends on how extensive the
and who's that up
problem
to?
is.
Is that up to the mayor or the chief of police that they're reporting to, or is it up to the Secretary of Homeland Security? You see, that's precisely what Alito's talking about in the New Jersey case. He says you're creating different lines of command and authority, and that doesn't follow American federalism. Everybody's got to be reporting either to a state government, a local government, or the federal government.
Again, the basic issue that we have, and Mr. Chairman, I'm happy to yield to you as well, is sanctuary jurisdictions preclude any involvement with federal enforcement. And that's too far, and it's harmful.
By citizens? By citizens?
By law enforcement. By
Okay,
sheriffs,
so in other words,
by police, and so forth.
They're saying that people who work for us, we don't want you spending your time enforcing federal immigration laws. Is that right? And why don't they have the right to do that?
Well, it's beyond that.
Well, should we, okay, let's flip it over. Going back to Prince, should we give local officials the right to enforce federal gun laws? Right now, they don't have the right to do that because of the Prince decision.
Well, they do have the right in this sense. If they arrest someone who's committing a federal crime, it can be referred to the federal government. And that's exactly the same principle here.
Well, within the chain of command, within the authority of the local government.
Sure.
Okay, well then that's exactly the situation we have now.
I have used local, state, otherwise non-federal law enforcement testifying in federal court. I've used them as witnesses. I've used their jurisdictions to bring into a federal forum.
Right, but not against the policies of the jurisdiction.
And I don't know that a state could preclude that.
Yeah, and I don't know that a state would. It just shows what bad relations are right now between the Secretary of Homeland Security and the state and local governments, but I hope we can improve those. But in the meantime, I would say, let's pass something saying there's got to be a notification before anybody's released from jail, if that's the issue, because you move me on that. But beyond that, we can't commandeer their personnel in this way.
For the record, I'm in full agreement that the federal government cannot compel action. But I also believe that state governments cannot preclude cooperation. That's the distinction.
Well, the ranking member is for compelling action. He's for compelling them to notify the federal government if they're going to release someone. He just said he was for that and said he'd support legislation if, in fact, that was what the legislation said, which I think it does. The question occurs on the amendment offered by the gentlelady from Washington. All those in favor say aye. No. All those in favor say no.
No.
Yeah.
Vote, Mr. Chairman.
Excuse me. All those opposed say no. No.
A roll call vote on those three votes.
The chair, the noes have it. Roll call being requested. The clerk call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Issa votes no. Mr. Biggs? Mr. Biggs votes no. Mr. McClintock? Mr. McClintock votes no. Mr. Tiffany? Mr. Massey? Mr. Roy? Mr. Roy votes no. Mr. Fitzgerald? Mr. Fitzgerald votes no. Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Schmidt? Mr. Schmidt votes no. Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler?
Aye.
Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz?
He'd come earlier if you
Mr. Goldman? Ms. Crockett? Mr. Cohen, you're not recorded. Mr. Cohen votes aye.
Clerk will report.
Mr. Chairman, there are 10 ayes and 13 noes.
The amendment is not agreed to. Gentlelady from Vermont is recognized.
Thank you, Mr. Chair. I must just take a few moments to respond to the remarks of the member from California, Mr. McClintock. He earlier called us hypocrites and said that Democrats are hell-bent on protecting violent felons. Now, from where I sit, President Trump created his own system of sanctuary and safe harbor when he pardoned all the January 6th insurrectionists, including violent felons. He pardoned all of those who mercilessly beat law enforcement and sent them back out onto the street to reoffend, including sexual assault against minors. And I just want to remind everyone that when individuals receive these kinds of presidential pardons, there is no traditional system for monitoring these folks. There's no parole system to keep tabs on them. That means the January 6ers were freed and unleashed upon our communities to commit more crimes, and they did. 6 of the January 6 insurrectionists have been charged with committing child sex crimes, from sexual assault to possessing child pornography. This includes Andrew Paul Johnson, who was convicted of 5 charges, including molesting a child under 12 and another under 16, as well as lewd and lascivious exhibition. This is a man who self-proclaimed himself an American terrorist. And I don't remember a single member of this committee, and I might be wrong, I might be forgetting someone, but I don't remember a single member on the Republican side who stood up and criticized this president for giving full pardons to violent felons and releasing them back out into our communities, out onto our streets to prey on Americans, including children.
Will the gentlelady yield?
I will.
I'm so glad you raised the case of Andrew Paul Johnson, which just came to my attention yesterday. This is extraordinary. This guy had several child sex abuse convictions before he participated in the violent insurrection incited by Donald Trump on January 6th to support his political coup. Then, after Donald Trump pardoned him, he went out and committed more sexual abuse against children and told one of his victims, who said he was going to report him, that don't worry about it, I will be able to pay you off because I'm going to get money as a January 6th patriot from Donald Trump in the Department of Justice. I yield back. Thank you.
I yield the balance of my time to the member from Washington, Ms. Jayapal.
Thank you. I wanted to just go back to the previous amendment, actually, because I noticed that it's much more comfortable for many people on this committee to talk about the constitutional protections, but not to talk about the effects of what happens if you take away federal funding from funding local and state efforts to fight domestic violence and sexual assault. And I noticed, I was accused by my colleague from California of conflating two totally separate issues. And I want to go back to that because I think it's important that we discuss this. These two issues are not conflated. The way the bill is written today, if you essentially implement a sanctuary city law, which is the right, and we've been talking about the constitutional reasons why it's the right of elected state officials to implement that law, to institute that law, this bill would take away all federal funding. That includes programs that fund all of the work to protect victims of sexual assault and domestic violence. That is the majority of funding that states and localities use on that topic. That's why the Violence Against Women Act was passed. And I don't understand why 172 Republicans voted against the reauthorization in 2021, but I think it is totally relevant. And these two things are not separate. They are the same. What this bill is proposing to do is take away that money if states don't do what the federal government wants it to do on enforcing immigration law. And so we should have spent more time on that amendment, which instead got turned into some argument that we were conflating two totally separate issues. They are not. And I want people to understand that if you when you voted against my amendment, you voted to strip localities and states of the ability to actually continue to go after those people who perpetrate sexual assault and violence. And I thank you, Ms. Ballant, for yielding, and I yield back.
And I yield back.
Gentlelady's times are expired. Who seeks recognition? Gentlelady from Pennsylvania, Ms. Scanlon.
Thank you, Mr. Chairman. I have an amendment at the desk.
Clerk will read. Point of order reserved by the gentleman from California.
Amendment to the amendment in the nature of a substitute to H.R. 7640.
Without objection, Madam is considered as read. Gentlelady is recognized.
Thank you. My amendment would ensure that state and local law enforcement do not participate in federal immigration enforcement actions that violate our Fourth Amendment right to be free from unreasonable search and seizure in our homes. Earlier this month, two whistleblowers provided Congress with a May 2025 memo signed by Acting ICE Director Todd Lyons. In the memo, Lyons purported to authorize ICE agents to forcibly enter homes with only an administrative warrant that is issued by ICE, a document that is simply signed by ICE supervisors without ever being reviewed by a federal judge. It's under this misguided policy that we've seen DHS agents in Minnesota and elsewhere forcibly enter people's homes without judicial warrants and without consent to conduct arrests. And that is conduct that the overwhelming majority of Americans reject on a bipartisan basis. And here's why this matters. Earlier this year, we saw masked immigration agents force open a door and enter the home of U.S. citizen Chong Li Tao in St. Paul. Agents refused to produce a warrant or look at the identification documents Mr. Tao tried to show them to prove that he was a U.S. citizen. They held him at gunpoint in his home, then hauled him from his home into sub-freezing cold, wrapped in a blanket and wearing nothing but his underwear and sandals. If DHS had to go before an Article III judge to get a warrant, the judge would have started with some basic questions. Do you have the right house? Do you have the right person? How do you know that the person you're looking for is at that house, is not a citizen, or has violated U.S. immigration laws? If DHS had to apply to a judge for the warrant and answered those questions truthfully, no warrant would have been issued because DHS had the wrong house, they got the wrong man, he was in fact a citizen who had not violated our immigration laws, and he had no criminal record. This is what happens when you treat fundamental constitutional rights like a paperwork requirement. And as this incident shows, it affects everyone, including U.S. citizens. The Supreme Court has repeatedly held that in the absence of specific exigent circumstances, the Fourth Amendment requires that search and arrest warrants for a home be issued by a neutral and detached magistrate, not an ICE supervisor engaged in immigration enforcement operations. This is to ensure that no search or arrest proceeds without a disinterested determination of probable cause, and that the central question is whether law enforcement has its facts and law straight, rather than whether ICE agents will be able to meet Stephen Miller's daily quotas. Even ICE's own training materials acknowledge that judicial, not administrative warrants are required to enter a home. So the law is clear. ICE doesn't have the authority to overturn legal precedents, much less to ignore one of our fundamental constitutional rights. I hope everyone can agree that in addition to preventing federal agents from breaking into people's homes without a warrant in violation of the Fourth Amendment, we should not be implicating state and local officials in this unconstitutional conduct. I urge everyone to support my amendment, and I yield back.
Gentleman yields back. Gentleman from California is recognized.
Thank you.
Point of order is withdrawn.
I withdraw my point of order and would like to address this amendment. You know, the Democrats are arguing that a judicial warrant signed by a federal judge should be required for these arrests. So that simply defies longstanding law and common sense. Let's begin with some basics. Deportation is not a punishment, and for that reason, it doesn't invoke criminal due process protections. Illegal entry is a crime, and repeated illegal entry is a felony. But illegal presence is a civil matter that's addressed through the civil act of deportation. Federal law requires that all such persons, quote, shall be detained. There's nothing discretionary about it. They shall be detained. That's the law that Biden ignored for 4 years. But unlike a suspect that's held for committing a crime, the alien is free to leave detention anytime they want, for any country that will accept them. They're simply not allowed to return to our country. Now, for decades, federal immigration law has authorized the use of administrative warrants for the arrest of illegal and criminal aliens in the country. Under current law, quote, on a warrant issued by the DHS secretary, an alien may be arrested and detained pending a decision on whether the alien is to be removed from the United States. That's from the U.S. Code. Both Republican and Democratic administrations have used administrative warrants to arrest aliens in the United States. An administrative warrant requires an immigration officer to determine that an alien is removable from the United States with a determination based on several factors, including ongoing removal proceedings, or biometric confirmation that the individual is inadmissible and removable as an alien. The Supreme Court has long recognized the federal government's authority to issue administrative warrants in the immigration context. And since deportation is not a criminal matter, there's no avenue to get a judicial warrant. Such a requirement would make immigration enforcement impossible. And the Democrats know that, and they're betting that most Americans don't. Democrats know if they could ever get this requirement, immigration enforcement would be impossible, and that's clearly their aim, and anyone who listens to the debates on this committee knows that. I'd also just point out two cases that are instructive. There's the Lucas case where the Eighth Circuit Court upheld the use of an administrative warrant signed by a prison warden to enter a residence and arrest an escaped inmate. And then we have the Abel case where the Supreme Court ruled that an administrative warrant issued by an INS official, the forerunner of ICE, was sufficient to enter a rented room and to extract an illegal alien. Once again, there is a consistent principle that is running throughout this entire debate. The Democrats want to release dangerous criminal illegals back onto our streets rather than deport them as law requires. And I'd be happy to yield to that.
I think it's interesting. You raise a great point. They want no process for people who want to enter the country illegally, an infinite process for people that we are trying to remove who are here illegally. And you stated it very aptly that if this amendment were accepted, it would bring any immigration enforcement to a halt just as a timing issue, right? There are 20 million illegals plus. If you spend 1 minute per illegal, 1 minute per illegal trying to get some type of Article 3 warrant, which is an entirely different article than immigration law exists, that's almost 20 years of actual time. So again, no process upon entry, infinite process to remove. You have essentially legalizing 20 million people in this country. I think the gentleman stated it very well. And I'll also submit this just for your consideration. The administrative warrants that you refer to, they have been accepted, and they come after a final removal order has been issued by an immigration court. The amount of process that is required to receive a final removal order is staggering. It's staggering. And to add one more layer of process that should be required to remove someone who is here illegally is unbelievably naive if you claim to be for immigration enforcement. So I appreciate your comments. I appreciate the spirit of your advocacy, and I yield back.
Would the gentleman yield?
Time belongs to the gentleman from California. Gentleman yields.
Thank you. I think both of my dear colleagues have totally missed the point. The question that I raised was whether or not a warrant must be issued before immigration enforcement, before state and local officials enter people's homes in order to enforce immigration orders. What you're suggesting would blow an entire hole in the Fourth Amendment.
Reclaiming my time, the Eighth Circuit Court of Appeals, which includes Minnesota, has ruled exactly that. In the case of an administrative warrant issued, in this case by a prison warden, to enter a residence and arrest an escaped convict.
Gentleman's time has expired.
Mr. Chairman? Okay. Mr. Chairman?
I think
Ms. Lofgren.
the gentlelady from California is recognized.
First, let me thank the gentlelady for offering this amendment. I think it is an important one. And I think it's important to make the distinction that is being lost here, which is, in fact, violations of immigration status is a civil offense. It's not a criminal offense. And there is a long set of cases indicating that administrative warrants can be used in civil matters. We're not disputing that. So if there is someone here who's undocumented and there is a final order of deportation and an administrative warrant, and that person is found on the street, that administrative warrant can be utilized in enforcing the civil offense that is presented. That is very different than breaking into somebody's house without a warrant, as the Fourth Amendment requires. And to conflate the two is seriously in error. The Lucas case that was referred to was split, but also relied on the fact that this was an escaped prisoner and that they were chasing the escaped prisoner with the warrant in hot pursuit. It had nothing to do with relying on an administrative warrant as a basis for breaking into somebody's house.
What about the Abel case?
I just want to get into the discussion of why the Fourth Amendment protects us. We showed a video yesterday of a United States citizen, an elderly man, who they broke down his door, they held him at gunpoint, and they marched him out in his underwear into sub-freezing temperatures. I don't know why they did that, and the secretary was unable to explain it, but it was all a mistake. I mean, and had they indicated, gone as the Fourth Amendment requires, to get a warrant to break into somebody's house, they would have quickly discovered that this was a U.S. citizen with no criminal record. They had no business doing what they did. I would like to just note that there was a lot of thrashing about when a warrant was issued for a search of President Trump's property, looking at classified documents that should not have been there. A raid, outrageous. Well, there was a warrant issued for that. I don't hear the same kind of concern being expressed when there's no warrant and American citizens are in their homes. And I'll just like to say, Justice Scalia wrote, when it comes to the Fourth Amendment, the home is the first among equals. And the court has ruled that the physical entry of the home is the chief evil against which the wording of the Fourth Amendment is directed. So I would hope, and I know that there are, and I have friends on the other side of the aisle who believe in the Fourth Amendment and the sanctity of one's home, that this could be, and as I say, the administrative warrant for the civil law violation, we're not disputing that. That is the law, and it's consistent with the Constitution. But breaking into people's houses without complying with the Fourth Amendment is not. And this is something that I would hope that we could come together on as a committee. And I would, I didn't teach constitutional law when I was teaching law, but the ranking member did, so I would like to yield.
Thank you, Ms. Lofgren. Look, that was really an excellent explication of the fundamental importance of the Fourth Amendment and the search warrant requirement. But Ms. Scanlon's amendment raises a point that makes this even more important, because her amendment says any of these new local or state employees who are suddenly transformed into de facto federal immigration officers must respect that Fourth Amendment principle. If you vote against this, understand what you're voting to do. You're voting to say state and local officers who suddenly have been given a private right or a public right, I'm not quite sure what, to participate in federal immigration law enforcement however they want, don't have to comply with the requirements of the Fourth Amendment if you vote against this. So thank you for giving us the opportunity at least to make a tiny improvement in the wreckage of this bill.
I yield back, Mr. Chair. My time's expired.
Gentlelady yields back. The gentleman from North Carolina is recognized.
Just briefly, in regards to the gentlelady's claims, which were very aptly stated, I enjoyed the discussion, but in regards to the Mar-a-Lago case, the issue is not with the warrant. It was that local law enforcement agents on the ground said we do not have probable cause to enter the president's residence, and those agents were overridden by Washington, D.C., who ordered them to make entry pursuant to their investigation. So there's a little bit of a difference there. But secondly, this idea that we're for the warrant or against the warrant, there's already a warrant that's being utilized. It's just not the type of warrant that's being sought by my colleagues on the other side of the aisle. This is a long-standing tradition that an administrative warrant is suitable when someone has been ordered removed from the country. If someone has been ordered removed by the country, they have been afforded exhaustive process, which in my opinion satisfies any reasonableness standard under the Fourth Amendment. Once they've been ordered removed from the country, they should not be afforded sanctuary if they flee to a residence. And if they do flee to a residence, an administrative warrant for the purpose, as Mr. McClintock so aptly stated, for retrieval and deportation. It's not a criminal investigation. It is not for prosecution. It is to return them home. Adding additional process on top of the exhaustive process they have already been afforded is a needless step, in my opinion.
Would the gentleman
I'm
yield?
happy to yield.
Just one note. I mean, there can be an exhaustive process, or, we removed in 1996, the requirement for actual notice for people of their hearing. And so a substantial number of removals are because the person didn't show, and of them, many of them never knew there was a hearing because they never got notice. So just a little note on that point. There are exceptions to the Fourth Amendment warrant requirement. One is consent, which obviously is not the case here, or exigent circumstances. Now, if the scenario you described, you've got someone who is subject to removal, they have an order, you have an administrative warrant, you're about to take them and they run away, you have an exigent circumstance. That's quite different than a non-exigent circumstance, and using, an administrative warrant is like note to self, you can break into somebody's house. That's not what the Fourth Amendment requires. And I just think to conflate the two is legally incorrect, and I thank the gentleman for yielding.
Well, I'll say this. You explained that in a way that might surpass the ranking member's abilities. I don't want to throw you under the bus, but she was very, very well stated. Mr. McClintock, you said you wanted?
Yeah, if I could,
be happy to yield.
just to point out that the question is whether an administrative warrant is sufficient to enter a person's home for the enforcement of our immigration laws. When the Luke's case, the Eighth Circuit said yes, and in the Abel case, the Supreme Court said yes, at least in the case of a rented room, not with respect to immigration, but with respect to other administrative warrants of exactly the same kind. And here's what the Democrats know, and here's the root of their position. Removal is not a judicial matter, and therefore a judicial warrant is simply not available. If they're successful in overturning the court precedents already established for administrative warrants, there's no way to remove an illegal alien, and that is their objective. I yield back.
Mr. Chairman, I yield back.
Well said. The gentleman from New Jersey is recognized.
Thank you, Mr. Chairman. I think I'm going to do a little bit of cleanup here. I'm going to back cleanup position over just a few things that were said and then to speak about this amendment. Violence Against Women Act was mentioned. I think just as a little refresher, that bill went through without any markups, no debate, no real discussion on the bill. It prohibited churches from getting grant money for shelters and for legal advice. Wrong thing to do. It really denied our Second Amendment rights because guns could be removed just on the basis of an accusation, which is crazy because a lot of accusations are made. Let me say in all candor here, I was one of, I think it was around 30 Republicans. I voted for the bill, but it was a faulty bill and it was really problematic and it put everybody in a bad spot. We could have done so much better to protect women. That was not one of our finest days. The Epstein files, I would remind my colleagues on the other side of the aisle, as I do frequently, that was brought up, that there was complete silence, basically 99% silence. I know that the ranking member sent a letter, a couple little things happened, but none of this occurred during the Biden administration. President Trump came in and there was a complete change of heart. And maybe that's a good thing. Maybe the president winning, besides the other good things he did, they really changed their thought process on this, their minds on it, and decided that something should be done. But basically, there was silence. You could hear the crickets. I'd also like to remind everybody that in this very room yesterday, we had the Angel Moms. I met with them after. I know a number of members did meet with them during the day. I'd really like to sit down. I would like folks on the other side to sit down with them and explain to them why they're never on that side speaking about the victims, the daughters and sons and mothers and fathers. You've heard me talk about it, that lost their lives, that have been injured, that will never be the same. We had a young person here that will never be able to walk in their lifetime because of an illegal criminal that was driving a vehicle. The stories were there. I had them in my office. They were in tears. Everybody was in tears. My staff were in tears. It's awful. Why in God's name? I don't understand it. And I didn't teach law. Guess what? I'm a dentist. But God damn it, I don't understand how you can constantly, repeatedly, consistently, over and over again, just defend the criminals and not care about these victims. We need to help the victims. We need to be safe. And people, literally, if we do what the other side wants, and I'm sorry to be so partisan here, but if we do what they want, people in America will die because of it. It's that simple. It's no more complicated than that. Finally, in this amendment, going back to the administrative warrant, it is suitable. These people that have already gone through a process, a lengthy process, an order is already in place. It's suitable, it's sufficient, it's appropriate, and the courts have said so in multiple cases. Chairman, I yield back.
Gentleman yields back. The chair now gentleman from Maryland is recognized. I'll give the gentleman from Kentucky.
Forgive the digression, Mr. Chairman, but sometimes I have to do that in answer to my friend from New Jersey. Here is someone else who had a complete change of heart about the Epstein files after the election of Donald Trump. Donald Trump. Because Donald Trump was demanding the release of the files, and then he got in and all of a sudden wanted to sweep the entire thing under the rug. And it was only when the courage of Mr. Massey and Ms. Mason, several other Republicans, entered the picture and joined the Democrats that he decided he wanted to try to get out in front of the parade at the end and say he was for it. And yet the administration has been doing everything in their power to sandbag us and to sabotage the actual release of the Epstein files. Now, the gentleman, I don't know how many times we can go through this chronology, and I'm happy to offer you all the memos and letters that I sent. I've been on this for many years. I demanded an investigation into the original dirty deal that they made in Florida, that Alex Acosta made, to trade a 60-count federal indictment that was ready to go for one measly state count of solicitation to prosecution. So I've been talking about this since for 7 or 8 years through Democratic and Republican administrations alike. What was President Trump's record and Pam Bondi's record? They got in, Mr. Van Drew, and I don't know if you understand this, but they got in, they fired the lead prosecutor, Maureen Comey, then they demanded all of the file and they declared it over. They ended the investigation. And when you say, well, why didn't Biden do anything? Ghislaine Maxwell was convicted under the Biden administration, Department of Justice, although we don't accept your conflation of the president with the Department of Justice, because in the old days, we used to have some respect for the independence of the justice function. But in any event, it was during the Biden administration that she was convicted, and that investigation under Maureen Comey continued under the FBI. So why wasn't it released? Why wasn't anybody demanding it be released on the Democratic side, Republican side? Because there was an ongoing investigation happening at that time.
Will the gentleman yield?
Yes, by all means.
The volume was not nearly what it is now.
The volume of what?
The intensity of concern with it, of opposition to what was going on.
Well, then,
look, I agreed.
I've got to reclaim my time, Mr. Van Drew, because you're just wrong about that. In fact, that's what the gentlelady from Washington was being chastised about, that she couldn't get off of the subject of sexual violence against women and children. And that's what this is about. That's why the whole country's in an uproar about this effort by the Bondi Department of Justice to bury the whole thing. And we should be talking about that, how we can get them to actually turn the files over. So that's the first point I want to make. Then, Mr. Van Drew, you also said that you met yesterday with the victims whose family members were killed by undocumented people in the country. By the way, those undocumented people got in both under Democratic and Republican presidents, and we can show you all the documentation of that if you think somehow there were no illegal aliens who got into the country under Republican presidents. But in any event, I'm glad you met with them, and I talked to them too when I was here. I didn't know they were coming, so I wasn't able to meet with them in my office, but I talked to them while they were here. You said, how about the people on the other side of the aisle meeting with victims? Are you kidding me? Who do you think is fighting for the victims of sexual violence and human trafficking in the Epstein files if it's not everybody on our side of the aisle? Have you met with them? Because I'll give you their phone numbers.
I will
in 1 second. I will set up a meeting with those victims to come and talk to you. How about I mean, any victims of sexual violence who are upset about the fact that Doge and Elon Musk slashed hundreds of millions of dollars for funding for programs related to sexual violence. Would you like to meet with some of them? We can arrange that too. And how about this? This is a really radical idea. How about meeting with the hundreds of thousands of victims of gun violence in America who are demanding effective action like a universal violent criminal background check in America? Would you meet with them? And I'm happy to yield.
Thank you. Yes, I would, and I have, and I just would think of my friend Chris Smith, who's been working for decades, not years, decades as a member of Congress against violence against women, against trafficking of children, trafficking of women, and I've always keep a constant connection with him, and I have met with those individuals as well. And by the way, saying both Democrats and Republicans is a dumb thing. I can't answer for every Republican, but I will tell you that if something's wrong, it's wrong. We want to straighten it out now. Illegal criminals should not be kept in the United States.
Okay, reclaiming my time, and we agree with that.
Dem or R says that.
Reclaiming my time. We all want criminals prosecuted and violent criminals to be put in jail or deported from the country if that's what's appropriate. And let's establish that that is the baseline of what we're talking about. And I assume you don't want innocent U.S. citizens to be shot in the face. And I hope some of you would take a moment to say that as well. I yield back.
Gentleman yields back. Gentleman from Kentucky is recognized.
I might have a unique perspective here. Unlike the Democrats, I support this bill, support the underlying purpose of it. But I'm interested in this amendment. I was very interested when Mr. McClintock reserved a point of order. I thought maybe we would debate whether this is the right place to have the debate on whether you need a warrant to enter into a residence. This debate does belong on an authorization of DHS bill. The problem is we haven't done that. We're not doing that. We haven't done that in a long, long time. And we should, that's where this debate belongs. There would be an opportunity to have this debate on the spending bill, which is stalled right now, the DHS spending bill. I think that would be a good place to put it, a limitation amendment that says none of the funds hereby appropriated shall be used to enter a residence without a judicial warrant. We can sort of, any one of us could write that amendment right here now. The problem is we've had so many closed rules from our Rules Committee that I don't think they're going to allow us to have that debate there either. So it turns out this is the place to have the debate. And you know, my party didn't raise a point of order, so let's have the debate. Anticipating this debate, I asked Secretary Noem yesterday what her opinion was on judicial warrants versus administrative warrants when you enter into a residence. And I believe she tried to assuage my concerns. She said that out of the thousands of arrests and incidents, this was only an issue in 28 of the arrests. Now, if I'd had more time, I would have asked two questions. Well, why even try those 28 arrests? Or number two, could you have completed 26 of those arrests if you had gotten a judicial warrant? Or maybe all of them. Was that an impediment in that very small number of cases that she claims that this is actually a debate? So with, you know, keeping in mind what Secretary Noem said, which is this is a very rare occurrence, I actually don't think this amendment is a poison pill. This is another test that I apply before I vote for an amendment that, I'm sorry to the members of the other side of the aisle, have to kind of look a little bit, with a little bit of scrutiny when you offer amendments to make sure these are not poison pill amendments, because like I said, I support the underlying bill. I feel like a few of these earlier amendments that say, well, except in cases where you violate the Constitution, I understand that's just kind of a dilatory amendment that doesn't mean much, but in this case, I think you have a real amendment. I think this might be the only place we can have the debate, unfortunately, because everything's so closed. I've been assured by Secretary Noem this is just a very minor issue that Republicans shouldn't be concerned about. And so I'm going to support the amendment. And because this is about the Fourth Amendment, and do you need a warrant to enter not some squatters' encampment, of illegals who just came over the border. We're talking about going into American citizens' residence, right? These are legally owned homes and apartments owned by American citizens. So I understand, we need to pursue illegal immigrants and deport them, but why can't we still maintain respect for the Constitution and say that if you're going to enter an American's home with law enforcement and you're not in hot pursuit and somebody's not about to die, why can't you just spend the extra few hours to call up a judge and ask for a warrant and make sure that we're a republic, that we've got 3 functioning branches of government? So with that, I just want to say I support the amendment and I yield back.
Gentleman yields back. Question occurs on the amendment offered by gentlelady from Pennsylvania. All those in favor say aye.
Aye.
All those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment
I
is
got to ask for a recorded vote on that one.
being requested. The clerk, we need to make sure we get members in here. The clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? No. Mr. Biggs votes no. Mr. McClintock? No. Mr. McClintock votes no. Mr. Tiffany? Mr. Massey?
Yes.
Mr. Massey votes yes. Mr. Roy? Mr. Fitzgerald? Mr. Klein? Mr. Klein votes no. Mr. Gooden? Mr. Gooden votes no. Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? Mr. Moore? Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Grothman votes no. Mr. Knott? Mr. Knott votes no. Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Mr. Johnson? Mr. Swalwell? Mr. Liu? Ms. Jayapal? Ms. Jayapal votes aye. Mr. Correa? Ms. Scanlon? Aye. Ms. Scanlon votes aye. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett?
Gentleman from Alabama.
Mr. Moore votes no.
Gentleman from Wisconsin.
Mr. Tiffany votes no. Mr. Kiley, you're not recorded. Aye. Mr. Kiley votes aye.
Clerk will report.
Mr. Chairman, there are 11 ayes and 14 noes.
The amendment is not agreed to. The question occurs.
Oh, gentlelady from California.
Okay. Gentlelady from California is recognized. Did you say?
I did say I have an amendment at the time.
Okay, I didn't hear all that. The clerk will report. Point of order reserved by the gentleman from California.
Amendment to the amendment.
Without objection, the amendment be considered as read. The gentlelady from California is recognized to explain her amendment.
Thank you, Mr. Chair. This amendment would limit the right of state and locals to enforce or cooperate with immigration laws if it involves a search of a home without a judicial warrant as required by the Fourth Amendment. No, that's the last one, sorry. This amendment, but we're continuing on a thread. This amendment would ensure that when state and local authorities are being co-opted to do immigration enforcement, that they are not acting like DHS personnel and wearing masks to shield their identities. So across the country, we have seen incidents of hooded or masked ICE and Border Patrol agents grabbing law-abiding immigrants off the streets in scenes that could easily be confused for kidnapping. But we've also seen it, and they're doing it not just with immigrants, but also with U.S. citizens. Masked federal agents operating without identification, explanation, or transparency are not restoring order. They are creating chaos. Videos of these and other arrests have gone viral on social media, evoking images of the masked police forces in the Eastern Bloc. Traditionally, masks have only been used by law enforcement in this country when necessary to preserve the integrity of an undercover operation. Even when taking down the most dangerous criminals like John Gotti or El Chapo, police officers didn't feel the need to conceal their identities. So why is there such a need for secrecy now? In fact, masked agents failing to identify themselves has led to a spike in criminals impersonating ICE, robberies, assaults, and kidnappings. It has been happening so frequently that the FBI had to issue a national bulletin warning officers about the trend. For example, in Delaware, 2 men wearing vests labeled ICE pulled a man over, removed him from his vehicle, took his wallet while wielding a knife and a firearm. In Colorado, a masked man walked into a grocery store with a semi-automatic gun in a holster on his hip. And when an employee told him that firearms were not allowed in the business, he flashed a fake ICE badge. In Florida, a woman wearing an ICE shirt and a mask kidnapped a hotel clerk who later was able to escape. In Pennsylvania, a man wearing a mask and impersonating ICE entered into an auto repair shop, yelled immigration, tied up a woman who remained in the store, and stole $1,000 in cash before fleeing. In New York, a man ordered a man into a basement stairwell after telling her he was an ICE agent, and he assaulted her and robbed her. In North Carolina, a man allegedly posed as ICE, showing a badge and threatening to deport a woman if she didn't have sex with him in a motel. In South Carolina, a man presented himself as an ICE agent to pull over and detain a group of Latino men. So one of the best ways to improve both officer and community safety is de-escalation. However, despite ICE training on de-escalation and its role in DHS's use of force policy, it is not being consistently used. And the many videos featuring aggressive tactics and unnecessary escalation suggest that this problem is systemic. So yes, we know already that impersonating a law enforcement officer is against the law, and hopefully we all agree that that is wrong. But by not creating or exacerbating this problem that is causing these kinds of incidents and unlawfulness, I think is also important. And so it does not make any sense to have local law enforcement jurisdictions who do not wear masks when they are doing their work to then be co-opted by DHS and take on a policy or a practice or a behavior that they wouldn't do themselves. That is what this amendment says simply. State and local law enforcement should not be forced to conduct immigration enforcement to begin, but if they are, at the very least, we should ensure that they do not wear masks, especially if that is not part of their own practice or policy. The public certainly deserves identification and accountability and not anonymity when these kinds of actions are taking place. We certainly don't see now when we're driving to the grocery store and we see one of our local law enforcement officers sitting in their car masked up. This is about community safety, and part of community safety is knowing who the folks are who are working to keep you safe. And with that, I yield back and ask for the support on this amendment.
Gentlelady yields back. The gentleman withdraws his point of order, and the gentleman from California is recognized.
Thank you. Well, Mr. Chairman, I've talked with a lot of ICE officers. Not one of them wants to wear a mask. The fact is, they have to wear masks to protect themselves and their families from doxing and the violence directed at them that comes from doxing. We even had one incident in Carpinteria where a Democrat member of Congress doxed a federal agent to a violent mob that then set off upon that officer and put him in the emergency room of a local hospital. So here's an idea. Let's forbid law enforcement from wearing masks, but let's also put those who harass or threaten or dox law enforcement officers or their families, or who share personal identifying information about them, to a mandatory 20 years in prison. And let's make an assault on them punishable by 40 years. And since what's good for the goose should also be good for the gander, let's forbid any demonstrators from wearing masks as well. But of course, the Democrats won't agree to this because their aim is to stop enforcement of our immigration laws and to whip up a lunatic fringe on their movement into violent confrontations. Gestapo, secret police, a reign of terror, a clear and present threat, slave patrols, masked thugs. Those are just a few of the words and phrases used by far-left radicals to describe ICE. And every single one of them came from the lips of a Democrat elected official. As those same Democrats stoke division and hatred and fear of federal law enforcement, they question why those same federal law enforcement officers don't want to show their faces. It's because those officers know the Democrats' playbook. Nearly a dozen violent assailants equipped with tactical gear and weapons attacked U.S. Immigration and Customs Enforcement Prairie Land Detention Facility in Alvarado, Texas on July 4th, 2025, shooting a local law enforcement officer in the process. Just days later, a gunman opened fire at the entrance to the United States Border Patrol Sector Annex in McAllen, Texas. These attacks not only endanger federal law enforcement, but the aliens themselves. Last fall in Dallas, a sniper targeted an ICE facility, shooting and killing 2 ICE detainees and injuring another. Meanwhile, death threats against ICE officers have increased 8,000%. Assaults on ICE officers have increased more than 1,300%. Even a Biden-Harris administration ICE official explained the dangers of harassment against ICE officials, saying the staff have had to deal with, quote, doxing by the public, including labeling them as Gestapo and plastering officers' faces on posters which were put up throughout the neighborhood. He also described how ICE had to board up its offices for several years in some cases, even shut down operations at certain ICE offices because the protesting became so significant. How can anyone be expected to perform their job to the best of their abilities under such conditions? But once again, the common theme, that is the objective of the radical Democrats today. So if Democrats want ICE to drop their masks, then they need to drop their rhetoric. But I don't think that's going to happen. In the meantime, ICE agents are doing the sensible thing to protect themselves and their families from the violent far-left radicals who are dead set on destroying our country. I yield back.
Gentleman yields back. The gentleman from New York is recognized.
Thank you. Mr. Chairman, I support this amendment, but I would go further. This amendment says that when state and local authorities are being co-opted to do immigration enforcement, they should not wear masks to shield their identities. I would say that when ICE agents are doing their job, they should not wear masks to hide their identities. They are no different than any other police officers in this country who always have identification so that you can hold them accountable if they violate the law. If they do their job properly, fine. If they violate the law, if they manhandle people, if they murder people like Alex Preddy and Rini Good, they should be held accountable. If, as happened in Colombia last week, I think it was, ICE agents impersonate police officers to come into someone's dorm room without a search warrant and take her out, they should be held accountable. And they misrepresented themselves. All police officers of whatever nature, whether FBI or local police or immigration agents, should be held accountable and should be identifiable so that they should be can be held accountable. And when they're masked, When people are masked, they often feel they can get away with anything. As we have seen with the murders of Renee Good and Alex Preddy. Those are murders. Now, if it weren't captured from multiple angles on video, we wouldn't know they were murders. We would have to take the words of the ICE officers. But the fact is, they were murders. And that's why when some of us sometimes say they're using Gestapo tactics in our streets, they are. And they shouldn't. No police officers of any nature, local, state, federal, should get away with that sort of thing. That's why they shouldn't wear masks. That's why the rhetoric about Gestapo tactics is accurate, because they're acting like unaccountable agents of a totalitarian system. We do not have a totalitarian system, but they act as if we do. I yield back. I'll yield to Mr. Raskin.
Thank you very much, Mr. Nadler. I just want to echo some of the things that you said. This amendment would prevent ICE's unique mask requirement from spreading to state and local government law enforcement. It's not enough for them that ICE is the only law enforcement or military or quasi-military or paramilitary agency in the country to wear masks. The Army doesn't wear masks. The Navy doesn't wear masks. The Coast Guard doesn't wear masks. The Marines don't wear masks. Local police departments don't wear masks. County police departments don't wear masks. State police don't wear masks, but ICE needs to. And the good gentleman from California assures us because somehow they're uniquely vulnerable to criminals going after them when it's a civil law enforcement or a civil enforcement agency. Really, is it more dangerous than being a police officer in most major cities in America? I don't think so. I don't know that we've lost any ICE agents. I know ICE agents have killed people. There have been 3 homicides in Minnesota this year, in Minneapolis, and 2 of them were at the hands of ICE agents. And yet the gentleman says they alone need to wear masks. Well, we don't know why. Nobody's ever given us a good explanation for it. I know that in this committee there was a vote which was brought forward by the Democrats to say that pardon January 6th rioters, insurrectionists, extremists, and terrorists, Proud Boys and Oath Keepers could not get hired with the billions of dollars showered on the Department of Homeland Security by the committee, and every Republican voted against it. Well, the new masking requirement is keeping us from knowing who's behind the mask. And we've been writing repeated letters to the Secretary of Homeland Security, to the head of ICE, to say, are you hiring January 6th insurrectionists, people who violently attacked our police officers? Are there people behind those masks who attacked the police and beat them up with Trump flags and Confederate battle flags? We're interested. You guys aren't interested in that so much. So we absolutely need to pass this to prevent this new masking policy from spreading into states and localities. Yield back.
Time of the gentleman has expired. The question occurs on the amendment offered. Gentleman from Illinois is recognized.
Thank you, Mr. Chairman. I move to strike the last word.
Gentleman's recognized.
I join my Democratic colleagues in condemning this disgraceful legislation. This bill unconstitutionally commandeers state and local law enforcement and strips federal funding from states and localities unless they agree to carry out Trump and Miller's lawless and authoritarian agenda against our communities in violation of the 10th Amendment. This legislation is the latest effort by Republicans to target jurisdictions that choose to build trust between local law enforcement and communities instead of turning them into instruments of federal overreach. It's especially appalling that Republicans want to force a markup of this illegal policy when our country is defending itself from the fascist violence unleashed on our streets by masked DHS thugs and Secretary Noem, who couldn't even defend her actions yesterday. And you only know this when you feel it in your neighborhood, in your community. Hear what I say about that. So here's what Republicans want local law enforcement to do alongside ICE and CBP. Murder American citizens and immigrants in cold blood. Shoot protesters who do not pose a threat to them, like Marimar Martinez, my guest at the State of the Union, who was nearly murdered by CBP agent Charles Exum. Racially profile people based on their skin color, accent, and workplace. I've seen it firsthand. Arrest people and break into their homes without a judicial warrant in violation of the Fourth Amendment. Rip families apart, kidnap grandparents off the street, tear children away from their parents, and toss them into concentration camps. Conduct mass surveillance to target protesters, journalists, and anyone else since Trump deems an enemy of the state. That's what Republicans want our local law enforcement to do. And they abandon any pretense of conservatism to do it. They wave their "don't tread on me" flags and then conduct a mass campaign of repression against the people of this country. They wave the "back the blue bags" and flags and strip funding from local law enforcement unless they do the bidding of DHS. They talk about government overreach and then cheer on the federal invasion and occupation of our cities, our own military. They talk about law and order and then incite mass violence on our streets. They talk about fiscal conservatism and then spend $170 billion, our tax dollars, on a slush fund for Trump, Noam, and Miller to carry out this agenda. We all know what's happening here. The Republican Party is controlled by violent extremists who have no morals, who don't give a damn about this country or the Constitution, whose entire job description is to lick Donald Trump's imaginary boots, who will sanction the murder of American citizens to keep their seat in Congress. And this bill is cruel and illegal on its face. And this is personal to me. I was proud to stand with Mayor Harold Washington, a former member of Congress, when his administration issued the executive order that made Chicago the nation's first sanctuary city in 1985. As a county commissioner, I fought to enhance trust between local law enforcement and the communities they serve. And I fought against the administration's assault on the Chicagoland region. I led an Illinois Democratic members delegation in opposing the administration's attempt to strip funding over the Illinois Trust Act and other welcoming policies, a tax that a federal judge ruled was illegal. I've brought my colleagues to Chicago so that they can see firsthand why our policies make us safer and why the Republican assault on welcoming policies threatens public safety for every one of us. And let us not forget, this enforcement is why the president's approval ratings have plummeted. And it's also why Americans across the country of all political stripes have believed now that ICE needs to be dismantled. It's the cruelty. I stand in solidarity with every immigrant, with every welcoming jurisdiction, and every person who opposes fascism in America. I oppose this harmful and illegal legislation, and I yield back and urge a no vote.
Gentleman yields back. Gentleman from Missouri is recognized.
Thank you, Mr. Chairman. Mr. Chairman, I cannot believe my ears. This is the party that for 2 years required everyone to wear masks. These same Democrats who are anti-mask today, they represent cities and states such as California, Hawaii, Illinois, Massachusetts, Minnesota, New York, Oregon, Puerto Rico, and Washington State that required everyone to wear masks. Many of them even required toddlers to wear masks, which did immeasurable damage to their speech and language development. But you know what masks did to prevent the spread of COVID? Nothing. On the other hand, our brave men and women of law enforcement, ICE, have been doxxed, they've been tracked, they've been spit on. Apps were developed to track ICE. And as has been noted, there was an 8,000% increase in death threats to ICE agents and their family members. So the agenda is clear. The agenda is clear. Anti-law enforcement activists want to be able to dox and track and intimidate ICE agents so that we will not enforce our borders, so we will not enforce long-standing immigration law. I urge this body to reject this amendment. I yield back.
Gentleman yields back. The question occurs on the amendment. You want to speak on the amendment? Gentlelady from Vermont's recognized.
Thank you, Mr. Chair, and I yield my time to the member from California, Ms. Kamlager-Dove.
Thank you, Congressman. I'm real talk. When I get on the airplane, I do wear a mask because there's some nasty folks out there, and the flu season is upon us. But I'm not getting on an airplane trying to hurt somebody, So separate the two. No theater today. My fellow congressman, colleague from Illinois said it right. The majority of the American people say that they have had enough with ICE, partially because of what they are seeing on their phones and on the TV. Masked vigilantes running up on people everywhere, in churches, at playgrounds, at parks, in the middle of the street, and shooting them in the face. Arresting 5-year-old kids, shooting refugees, detaining American citizens. They called Renee Good out of her name. They called her a B word as they shot her in the face. And Americans are saying enough of that. And they don't want to see those folks in their communities wearing masks. This amendment is simple. If you support states' rights, then conceivably you would also support the sovereignty of your local law enforcement jurisdictions. And if you support this amendment, then you say, well, I don't want DHS to commandeer my local jurisdictions and force them to do things that they don't want to do. Because if they wanted to wear masks, then they would probably have their own policy that says they can. But I've talked to my local police officers and sheriffs and firefighters, and they say that it's BS what they see with these ICE agents wearing masks. Secretary Noem came in here yesterday and was complaining about how, I wish I had more help from the local law enforcement agencies. Well, she's not getting any help from local law enforcement agencies because those departments are saying working with DHS is dangerous. It's putting my officers at risk. And they're also saying working with DHS, these ICE agents, is expensive. It's putting local revenue at risk. Because a local city could spend its time trying to raise its revenue to build you another park or build you another school or help with a hospital. Or they could be doling out settlements and lawsuits because their local law enforcement got commandeered by DHS and got folks running around wearing masks, shooting people and kidnapping people. And that's not what anyone wants to be connected to. Now, the representative from the northern part of my state was talking about don't hurt law enforcement. How about do an amendment that says don't hurt law enforcement? Well, isn't that what we've been talking about when we've been bringing up January 6th? Gentleman from across the aisle was talking about apologizing. Not no person from the other side of the aisle apologized to the police officers that were protecting them January 6th. Can't even get the plaque up. Had officers here for a couple of hearings. I didn't see no Republicans go over to them and say, thank you for your service. And when the president pardoned these people, some of whom went out and committed more crimes, not one Republican said that's wrong, that's a hot mess, president shouldn't do that. Now, I know you don't want to, you say, well, this is the president, he can pardon, he can do what he wants. But you can also say it's not a good idea. you can also say it's bad, because those people didn't dox a Capitol Police officer. They had tried to kill Capitol Police officers. So say something about that. This amendment is basically trying to uphold some sovereignty of our local law enforcement jurisdictions to allow them to do the work that they're trained to do, that they're actually taking seriously, unlike these ICE agents under DHS. I think it's as simple as that. And with that, I yield back to time.
And I yield back to the chair.
Gentleman yields. Gentleman from Maryland is recognized.
Thank you very much, Mr. Chairman. I want to introduce some stuff for the record, consistent with the remarks of the gentlelady from California. This is a January 6th rioter, pardoned by Donald Trump, was convicted of sexually abusing children. He was convicted of multiple state charges of child molestation and exposing himself to children. He was charged in Florida for new crimes after receiving a full pardon from President Donald Trump for his role in the January 6, 2021 riot at the U.S. Capitol. So if I could introduce that one from NPR, and then there's another one. January 6 rioter, pardoned by Trump, is convicted of child molestation. So there's another one I'd like introduced here. And it makes me think about the point made by my friend from New Jersey. It seems like there are worthy victims and there are unworthy victims. So yesterday, we saw a group of people come here who had lost their children when they were killed by undocumented aliens, criminals who killed them. And those people deserve our complete compassion and solidarity. Speaking as a dad who lost a child, I can only begin to imagine the horrors of what they've gone through, but enough that I could speak to several of them when they were here. Now, why is it that those are victims worthy of our attention, but Epstein's victims are not? Or the police officers who defended us, who got the daylights beat out of them by a rampaging mob? They're unworthy victims. They're people that some of our colleagues don't want to talk about. And so when we're dealing with these questions, it seems to me that we have to acknowledge the moral claims of everybody who's been victimized by violence and do whatever we can to reduce and to address the violence. That's why I asked my friend from New Jersey, would he be willing to meet with families who lost people to gun violence? And they might be brought in by groups that you don't think you like Brady or Gabby Gifford's group. Because that's who's able to organize them. But there are hundreds of thousands of people who've been affected by gun violence in schools in the country. Are we willing to hear them and talk to them? Or is that irrelevant because we've already foreclosed addressing their problems and engaging in any kind of public policy that might be responsive to their concerns? Think about it. Worthy victims and unworthy victims. I try to meet with anybody who comes to me with this story. I'm not going to close off entire groups of the population because I think they're going to tell me something that might somehow be at odds with my predetermined policy commitments. So what we're talking about today is something, though, that goes right to the heart of the constitutional structure of America. And I've tried to offer my colleagues a glimpse of these Supreme Court decisions. I really recommend that they all read. They're written by justices like Scalia and Alito, saying that the federal government cannot enter into state and local governments and conscript individual employees or officials, much less all officials and employees, to the effectuation of federal goals. It's a violation of the constitutional design. Check out Justice Alito's fine disquisition on that. He says that those of us in government have got to be responsible to the people voting for us and can't take orders from somebody else at a different level of government. And I think that's the essential point that we're talking about here today. We've tried to raise questions related to the trampling of people's constitutional rights, their First Amendment right to speak, to assemble, to protest for a redress of grievances, their Second Amendment right to possess a firearm without being killed simply because they are possessing a firearm in in perfect conformity with the Second Amendment and state law, and due process, and the Fourth Amendment. And yet, it seems like out of deference to one guy and a policy agenda that's out of control, that's being rejected by the vast majority of the American people, our colleagues are willing to close their eyes to constitutional violations they would never accept for one moment if it were being done under President Biden or Obama. None of these things, shooting people in the face, entering their homes without a search warrant, arresting people for protesting in public or recording government officials on camera. It would never happen. And it's hard for all of us to be consistent, but let's at least try to be consistent. I thank you, Mr. Chairman. I yield back.
Gentleman yields back. The question occurs on the amendment offered by the gentlelady from California. All those in favor of the amendment will say aye. All those opposed, no. No. In the opinion of the chair, the noes have it, and the amendment is not agreed
Request a recorded vote, please.
Clerk will call the roll.
Mr. Jordan?
No.
Mr. Jordan votes no. Mr. Issa? Mr. Biggs? Mr. McClintock? No. Mr. McClintock votes no. Mr. Tiffany? No. Mr. Tiffany votes no. Mr. Massey? Mr. Roy? Mr. Fitzgerald? No. Mr. Fitzgerald votes no. Mr. Klein? No. Mr. Klein votes no. Mr. Gooden? No. Mr. Van Drew? No. Mr. Van Drew votes no. Mr. Nels? Mr. Moore? No. Mr. Moore votes no. Mr. Kiley? Ms. Hageman? Ms. Hageman votes no. Ms. Lee? Mr. Hunt? Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Harris votes no. Mr. Onder? Mr. Onder votes no. Mr. Schmidt? Mr. Gill? Mr. Gill votes no. Mr. Baumgartner? No. Mr. Baumgartner votes no. Mr. Raskin?
Aye.
Mr. Raskin votes aye. Mr. Nadler? Aye. Mr. Nadler votes aye. Ms. Lofgren? Ms. Lofgren votes aye. Mr. Cohen? Yes. Mr. Cohen votes yes. Mr. Johnson? Mr. Swalwell? Mr. Swalwell votes yes. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes yes. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes aye. Ms. Ballant? Ms. Ballant votes aye. Mr. Garcia? Mr. Garcia? Mr. Garcia votes aye. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes aye. Mr. Moskowitz? Mr. Goldman? Ms. Crockett?
Gentleman from Texas.
No.
Mr. Hunt votes no. Mr. Biggs votes no.
Other gentleman from Texas.
Mr. Gooden? Mr. Gooden votes no.
Clerk will report.
Mr. Chairman, there are 10 ayes and 15 noes.
Noes have it. The amendment is not adopted. Question now is on the adoption of the amendment in the nature of a substitute. This will be followed immediately by a vote on reporting the bill. All those in favor say aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it, and the amendment in the nature of a substitute is adopted. The question is on favorably reporting the bill as amended. All those in favor say aye. Aye. Those opposed, no.
No.
The ayes have it, and the bill is ordered to be reported favorably. I assume you want a roll call. The roll call vote being requested. The clerk will call the roll.
Mr. Jordan?
Yes.
Mr. Jordan votes yes. Mr. Issa? Mr. Biggs? Aye. Mr. Biggs votes aye. Mr. McClintock? Mr. McClintock votes aye. Mr. Tiffany? Mr. Tiffany votes aye. Mr. Massey? Mr. Massey votes aye. Mr. Roy? Mr. Fitzgerald? Mr. Fitzgerald votes aye. Mr. Klein? Mr. Klein votes aye. Mr. Gooden? Mr. Gooden votes aye. Mr. Van Drew? Yes. Mr. Van Drew votes yes. Mr. Nels? Mr. Moore? Mr. Moore votes yes. Mr. Kiley? Ms. Hageman? Ms. Hageman votes yes. Ms. Lee? Mr. Hunt? Mr. Hunt votes yes. Mr. Fry? Mr. Grothman? Mr. Knott? Mr. Harris? Mr. Harris votes yes. Mr. Onder? Mr. Onder votes yes. Mr. Schmidt? Mr. Gill? Mr. Gale votes yes. Mr. Baumgartner? Mr. Raskin? Mr. Raskin votes no. Mr. Nadler? Mr. Nadler votes no. Ms. Lofgren? Ms. Lofgren votes no. Mr. Cohen? Mr. Cohen votes no. Mr. Johnson? Mr. Swalwell? Mr. Swalwell votes no. Mr. Liu? Ms. Jayapal? Mr. Correa? Ms. Scanlon? Ms. Scanlon votes no. Mr. Neguse? Ms. McBath? Ms. Ross? Ms. Ross votes no. Ms. Ballant? Ms. Ballant votes no. Mr. Garcia? Mr. Garcia votes no. Ms. Kamlager-Dove? Ms. Kamlager-Dove votes no. Mr. Moskowitz? Mr. Goldman? Ms. Crockett? Mr. Baumgartner votes aye.
We'll wait a couple of minutes. We've got a couple members who want to be recorded on the vote. While we're waiting, I want to thank the committee. I know it's been a busy week, but most weeks are busy weeks for this committee.
Thank you, Mr. Chairman, for leading us this week.
Who do you have coming? We're waiting for Schmidt. You guys have a couple.
Jayapal's running back from Foreign Affairs. She's literally on her way.
Yeah, we're waiting.
Thank you, sir. I appreciate that. There she is. Daryl's
Ms. Jayapal votes no.
You didn't need to run. I was going to wait on you.
Thank you, sir.
You bet. Thank you, guys. We'll probably do a call next week sometime. Gentleman from California.
Mr. Issa votes yes.
I'm just waiting for Derek. You traveling, Jamie, next week? Gentleman from Kansas.
Mr. Schmidt, you are not recorded. Mr. Schmidt votes aye. 1811. Mr. Grothman votes aye. Mr. Fry, you're not recorded. Mr. Fry votes aye. Mr. Nels votes yes. Mr. Kiley, you're not recorded. Mr. Kiley votes aye.
Okay. Clerk will report. Clerk will report.
Mr. Chairman, there are 22 ayes and 11 noes.
The ayes have it, and the bill is ordered to be reported favorably to the House. Members will have 2 days to submit views. Without objection, the bill will be reported as a single amendment, the nature of a substitute, incorporating all adopted amendments, and staff is authorized to make technical and conforming changes, and that concludes today's markup.